morning, everyone. We're here today for the hearing in the matter CFI 26-2017 before Justice Sir Richard Field. The applicant is represented by Clyde & Co. Lead counsel is Jonathan Chu. The respondent is represented by Altamimi & Co. Lead counsel is Tom Montague Smith QC, assisted by Tarek Shray and Peter Smith.
Mr. Chu?
Yes, my lord.
I've read the skeleton arguments more than once.
Yes, my lord.
And the background material. I think you're constrained to agree it's a relatively short point. Although you have a number of variations that you play on the main tune, it's a relatively short point. You've no need to take me through the background or the chronology. You can get straight to your legal argument.
My lord, I'm grateful for that indication. My lord, before I do, a matter has arisen that I want to bring to my lord's attention.
Yes?
The claim form refers to, this is page 43 behind tab 8, the claimant's general terms and conditions of business.
Yes.
In the course of preparation yesterday afternoon, those on my side emailed to me requesting that document on the basis it was referred to in a statement of case.
Yes.
My instructions are that my clients haven't seen that document before, and we received it outside court this morning.
Yeah.
We flicked straight to the back to see if there was, as one might expect, a law and jurisdiction clause. And if I can hand it up, we find that there is indeed an English law and an exclusive jurisdiction of the High Court of England clause. Now, that means that, as it stands, the claimants have included reference to a document in their claim form and pleaded that the DIFC courts have jurisdiction in circumstances where, as one sees in the first paragraph of 21, the general terms shall be governed in accordance with English law, and such claimants should refer to the High Court of Justice in England, to the exclusive jurisdiction of which each party hereby irrevocably submits. Now, of course, my clients deny the existence of the contract, but for the purposes of this discussion and jurisdiction, one proceeds on the basis of essentially the putative jurisdiction, well, the law and jurisdiction of the putative contract. And so in those circumstances, I will be adding this particular point to my argument.
Well, what is the point? What is the point?
The point is that there is, on the claimant's case, which one has to accept for the purpose of jurisdiction, an exclusive jurisdiction clause giving effect to England of the court. This court should give effect to that by staying in favour of England.
Well, are you making an application to that effect?
I say it within my...
You're just trailing this point around.
Yes.
As if you were setting a scent for the hounds, but having actually no fox to present to the court. Either make an application, or in circumstances where your clients deny that there was a contract under these terms, we get on and we decide whether this court has jurisdiction for the claim that is in front of it.
Yes, my Lord. I say I don't need to make an application because it's part of my existing form on convenience application.
Oh, you want it could then come in under that?
Yes.
All right, fine. I'll listen to what you have to say under that heading.
I'm grateful. Well, in that case, then I'll go straight to the legal points in my main argument, and I'll come back to form on convenience at the end, if I may.
Yes, Mr. Montague.
I hesitate to rise, Your Honour, but I would just like to lay down a marker that I do object to this late introduction of this document. There's, as I see it, an improper explanation for why this is raised now. It's put in front of me today. If there is to be an application to rely on this jurisdiction agreement, then my learned friend needs to rely on it. His client needs to assert its existence and rely on it.
Well, it is your wait a minute. It is your document. It is referred to in the claim form.
Correct.
And I think that I've been told in clear terms that there is no application to restrain your putative proceedings so that it can all be heard in London.
Yes.
And I think the best thing to do is for me to see how the matter is developed by Mr. Chick, keeping a wary eye on where we're going.
I'm grateful. Right, that's all. If the discussion moves to questions of strong cause to get around jurisdiction agreements, for example, then that is a separate issue.
Well, there's some jurisprudence on it.
There is jurisprudence on that, and there would need to be evidence on that. That's the point that I'm making today.
Okay. Thank you.
I'll leave it there for now.
Yes.
My Lord, I'm grateful. On jurisdiction as of right, I make three main points. The first is that this issue was, in my submission, left open by the Chief Justice in Corinth, and so it's a question for this court to decide as a matter of principle by interpreting the law. The second big point is that if there is no such restriction to the claimant-decided jurisdiction along the lines that I suggest, the DIFC courts have claimant personal jurisdiction, for example, for causes of action that arose in Dubai before its existence. And it's these courts that have jurisdiction and not the Dubai courts. I'll take that as my high example.
Is that part of your first point, or no? It's a separate point.
Yes, my first point is it's been left
It's
open.
left open, so I have an open landscape in order to decide.
Precisely.
Solution. Yes, and your second point was, just remind me.
My second point is that if there is no such restriction, the DIFC courts will have claimant-sided personal jurisdiction for causes of action that arose in, for example, onshore Dubai before the DIFC even existed, and it would be these courts in the DIFC that would have such jurisdiction, and not, as perhaps one might expect in those circumstances, the Dubai courts.
Yes, I see.
And my third point is that, again, if there were no such restriction, it would permit extreme forum shopping by allowing the claimant to pick where to sue.
Yeah.
And that will feed into, I say, that the general basis for the reluctance for there to be claimant-sided jurisdiction one sees in both onshore Dubai under the CPC and common law English law jurisdiction ordinarily is very much defendant-sided, with claimant-sided jurisdiction the last resort, and I say that's to stop exactly the kind of forum shopping that this wide interpretation would allow.
Yeah.
Now, my lord, you've indicated I don't need to take you through the authorities. I wonder if I might just direct you.
No, I didn't say that. I did not say that, or at least I didn't mean to say it. The factual background I've got clearly in mind, and that the alleged cause of action arose before the branch office was established and licensed, and a little bit of the tittle-tattle that's in both sides of witness statements. So that but yes, you must certainly take me to those parts of the authorities, although I'm more or less familiar with the general thrust of those authorities. You take me to those authorities to anything you want.
I'm grateful for the indication. I apologise for misunderstanding. Yeah. I don't propose to touch on the laws establishing the DIFC, but if I could just note as a starting point the objectives of the DIFC, because
yes.
I say when it comes to interpreting the judicial law, one has to construe it in the light of those objectives. That's page 325 behind tab 18 of the authorities, just for a
Page 325?
Yes.
Yes.
18/325, and it's Article 4 of the Law Number 9 of 2004. And that is, the centre shall have, without limitation, the following objectives: to be a financial centre in the Emirate, based on principles of efficiency, transparency and integrity, with a view to making an effective contribution to the international financial services industry. 4.2, to promote the position of the Emirate as a leading international financial centre, and 4.3, to develop the economy of the Emirate. And I say that such claimant-sided jurisdiction runs contrary to those objectives.
Yes.
Now, the Judicial Authorities Law itself and Gateway A is from Law's Note behind tab 20 at page 368. I don't propose to take you there, save to note that the Court of First Instance shall have exclusive jurisdiction to hear and determine civil or commercial claims and actions to which any licensed DIFC establishment is a party in A1. That's what I call Gateway A. That's, as I understand it, the only one relied upon. 5A2 is the operative jurisdiction that this court may hear and determine any civil or commercial claims or actions where the parties agree in writing, provided that such agreement is made pursuant to specific, clear and express provisions. One of the variations on my team is the contrast between the quite closely regulated and bilateral nature of the operative jurisdiction set against the exclusive, unilateral, one-sided claimant jurisdiction. Now, the first case that dealt with this in any material depth was Corinth,
Yes?
which is tab 2 of the authorities.
Just turn one up. There we go.
Great. And the discussion starts at page 22 within that.
Yes?
This was a case against Barclays Bank plc. Jurisdiction was refused at first instance on the ground that the DIFC branch of Barclays was not involved, and the appeal was made on the grounds that the branch is not a different legal entity to Barclays Bank plc, and therefore the plc as a whole
Yes.
was founded within the jurisdiction as a defendant. Now, points arising from that: one, primarily Corinth turned on the entity argument, if I can put it like that, branch versus legal person.
Yes.
Secondly, Barclays was, of course, the defendant in these circumstances. So,
Yes.
any particular issues about the claim didn't arise.
Yes.
And thirdly, as I said at the start, the point was left open. Now, if I can just perhaps make that good, I directed you, my Lord, to the discussion that starts at paragraph 57. The argument of the then Deputy Chief Justice below is rejected at 66, which is the
Yes.
entity argument. And then 67, my Lord, is worth reading because that deals with the exorbitant jurisdiction argument of the
Yes.
DIFC courts. Now that says we defeat any problems about exorbitancy, if I can call it that, by using foreign non-convenience.
Yeah.
Now, of course, there's a different solution to that within Dubai, within the UAE, but that's the mechanism identified there.
Yes.
Floodgates at 68A is parties can look after themselves by using jurisdiction clauses. Now, I say the answer to that doesn't work in this case for two reasons. The first reason is that the law has to amend what it always means, which means this is what it meant in 2004, which means that parties couldn't contract out to the DIFC because they didn't know it existed at that point. And my second point is that in accordance with the objectives that I referred to earlier, it is holding business and businessmen to unattainable standards of perfection rather than a reasonable standard of realistic business by expecting every businessman in Dubai, in the UAE or in the world to put an exclusive jurisdiction clause in order to avoid the risk of there being claimant-sided DIFC jurisdiction. Because one can posit an example relatively easily of, say, two internal Dubai or two internal Middle Eastern companies quite happily dealing with each other within one jurisdiction. One grows and expands and establishes a DIFC registered body, becomes a foreign recognised company, and all of a sudden there's DIFC jurisdiction for everything. I say in those circumstances to say that counterparties ought to have included a jurisdiction clause is unrealistic and defeats those businessmen's legitimate expectations. The paragraph 69 leaves open the applicability of foreign non-convenience in intra-Emirates matters.
That's gone now.
Precisely. So no more about that. And then 70 is where I say the Chief Justice left this question open.
Yes. Let me just look at that.
'70 and 71.
Yes.
And specifically, I'm sure the Lord's got it. I say this is a case where a recognised company in DIFC is seeking to sue any party outside the DIFC in respect of a matter which has no connection with the DIFC.
Yes.
I ought, for completeness, to draw your attention to Justice Chadwick's statement at 84, which is at the bottom of the next page.
Yeah.
Where he says the Gateway A jurisdiction is ad hominem, there is no further transaction-based requirement, so he says that's separate, that's B and C. I say that dictum, properly analysed, doesn't defeat my case, because I'm not seeking to apply a transactional link that's related to a transaction. I'm saying it's a temporal restriction referable to the personal jurisdiction, that is when someone registers those causes of action. So I say that's not a transactional link that interferes with B and C.
Yep.
In circumstances where forum non-convenience has gone in the evidence, I don't need to go into any further background on that. I refer, for my Lord's note, to the Choc and Mondial case, where the fact that an entity had close ties with the DIFC is not sufficient to found jurisdiction. That's Authority 5. Just to note that it is a carefully policed jurisdiction, if I can put it that way. And then the only other case I want to refer to in any detail is the Surrey case, which is Authority 8, where it's fair to say this was a very short judgment, but it did deal with the sort of points that arose.
Yes.
This was a claim for unpaid salary by an employee against a law firm, and at the time of the small claims hearing there was no jurisdiction. Following that initial hearing, but before the hearing of the appeal, the law firm registered as a DIFC branch, and the employee then argued that the DIFC jurisdiction was engaged as a recognised company. On the facts, the law firm, whilst it was registered, had a non-regulated commercial licence which didn't allow it to carry on business. And paragraph 13 is the key bit of reasoning, which is, as the DIFC branch is not currently authorised to operate as a law firm, I struggle to find that it can be a DIFC body or establishment within the intended meaning of Gateway A, as it is not in its present form able to perform the duties it was created for. Merely office space is not capable of satisfying the definition.
Yeah.
Corinth was then distinguished, and then I ought to note the penultimate paragraph 17. It may be that the question of jurisdiction could be revisited if and when the respondent successfully registers as a DIFC establishment in future, as mentioned above.
Yeah.
Now, the point I take from that is that that case shows that a pure literalist approach, even to Gateway A, is not taken, because here one had a body that did register and so became a registered, one would have thought, DIFC entity for the purposes of the law. But we see from this case, no, that's not enough. So, mere literal approach saying, yes.
Putting your temporal point on one side,
yes.
the claimants have established a fully functioning branch office in the DIFC at the time they issued the proceeding.
Yes.
Yeah.
Yes, so I don't say we're in this territory. My point's a different one. It's rather that if one were applying a purely literal approach to Gateway A, there would have been jurisdiction here because it was registered, and the definition in Article 2 says registered. That's the point.
It's really an authority at this level and at this stage in the development of the jurisprudence as to the meaning and effect of the definition.
The definition of registered, yes.
Yeah. Yes?
My Lord, they're all the authorities I propose to take you to.
Yes.
My Lord, has my primary case that jurisdiction is founded for claims where the cause of action has accrued after the claim's registration, whatever that means, we just looked at that. I'm going to set out my case in 5 propositions which focus principally on the alternative argument and then deal with the case against me.
Yes.
My first point in favour is what I call the extreme example of this conferring jurisdiction for matters that arose before the DIFC brought to existence in circumstances where no party could reasonably be expected to take account of it. Just from the law's note, that's paragraph 31 of my skeleton. But if, for example, in 1999, the claimant defendant contracted for the sale of certain services in circumstances where they are both within Dubai, there's no choice of law or jurisdiction clause. And I say in those circumstances where it's intra-jurisdiction, that would be a perfectly reasonable way for parties to act. If a claimant then, several years later, becomes a DIFC licensed entity or a centre establishment, then if there is no limit, any claims in relation to that CD contract established wholly internally in Dubai several years before the DIFC existed.
Well, within the limitation period.
Within the limitation period, yes. Would need to be litigated exclusively in these courts and not in Dubai.
Yeah.
And that places the defendant in a position where it needs to defend a claim in a jurisdiction that had no connection to the underlying facts, with which it has no connection, and which did not exist at the time of the transaction. And I say that is not something that this court should permit. So that's my extreme example. My second big point is that this is essentially retrospective, and the consequences that this has for parties. It means, first, they can't arrange their affairs in advance. Secondly, there is a substantial loss of party autonomy. For example, if we take the extreme example I used earlier, it may be the defendant chose not to engage with the DIFC because it preferred to keep its businesses onshore. It would then find itself forced to litigate in the DIFC. Now, again,
well, that point would apply, even if your temporal point didn't exist.
Yes, but it shows why one has to approach the unusual and exorbitant claimant-sided jurisdiction carefully. And so that's I can't argue there's no claimant-sided jurisdiction because that's not what the law says.
Yeah, that's right.
What I say is when one looks at the effect of that claimant-sided jurisdiction, it has startling consequences. if you're a defendant, you move somewhere and claims follow you, and there will always be somewhere for you to be sued to maintain your liabilities. But this claimant-sided jurisdiction interferes with parties' freedom of actions very substantially, and that is a factor that I say you would ought to bear in mind when interpreting this law.
Well, some might say it's one of the attractions to encourage parties to set up in the DIFC that they will have jurisdiction within the DIFC court for all claims that they may wish to bring.
Yes.
We're just putting the matter extremely broadly.
I mean, that...
Let me just make one, although it is a rather obvious point. Possibly the primary purpose of the establishment of this court was to provide confidence to business enterprises as to how claims might be judicially resolved in a court with commercial expertise where the language is English and where many of the claims will be on documents which are in English. And accordingly, if you come and set up here within the definition of establishment, you have this benefit, which is deemed to be of substantial one.
Yes. The difficulty with that is, my lord, is that there are two parties to every transaction, and it would be very easy for someone to essentially go around collecting contracts or potential liabilities, a factor, for example, and then establish themselves in the DIFC. Hey presto, as it were, there's jurisdiction for everything retrospectively, and their counterparties who, for whatever reason, were not engaged in any sense with the DIFC, find themselves put before a court that they had no interaction with whatsoever. And if one turns back to the objectives of the centre and the principles of efficiency, transparency and integrity, I say that actually the sort of one jurisdiction that the law posits is contrary to transparency, because it brings parties here who have no expectation they will be brought here. And I would also say it's contrary to integrity, in the sense that if the parties have reasonable, legitimate business expectations at the time of their dealings that they are in, for example, onshore Dubai, it would be contrary to this census objectives to allow a claimant unilaterally, retrospectively, to move them here. The proper way to do that, my lord, is under the provisions of the Judicial Authorities Law that allows the parties to opt in together. And that is policed very closely. It needs to be in writing, it needs to be clear, it needs to be comprehensible. Now, they are ways for parties to bring themselves transparently and effectively within the jurisdiction of this court in a way that's consistent with integrity and upholding parties' freedom of actions.
But putting on one side abuse of process and forum non-conventions,
yes.
If a branch office had been established before the alleged trade
Yes.
was executed, but the dealings between the parties were from London on the one hand into onshore Dubai on the other.
Yes.
You wouldn't have, after Collins, you wouldn't have a leg to stand on so far as jurisdiction is concerned, would you?
Not as of right, no, leaving aside problem. The answer to that is twofold. One is because of the temporal point, it allows the parties to investigate and do the research on their counterparty. Especially if they're here in Dubai, they're being contacted in Dubai by an English company.
Yeah.
There's an open register of foreign registered companies.
Yeah.
You expect parties to do due diligence.
No, really, if they're approached to do a trade like this, you'd expect the counterparty, the non-London counterparty, to see whether the people they're dealing with in London have got a registered establishment within the DIFC.
Well, if they don't,
Sounds a bit unreal to me.
if they don't, they either run the risk that they are here as of right, or there is always the foreign non-convenience argument, which is.
I've asked you to put that on one side for the moment, because I'm just looking at the primary question, which is how the law is to be interpreted.
Yes.
So far as the jurisdiction is concerned on these facts.
Yes. The first point is, in the circumstances the law posits, it would be open for a party to know whether or not it ran the risk of
Yes.
FC jurisdiction,
Yeah.
which it doesn't on my example.
Yes.
And the second point, I do come back to it, while the law is asking to put it to one side,
Yes.
one can't forget that foreign non-convenience is there to temper
Yes.
the strict literal application
Yes.
of the law,
As it is, you say, in this case.
as it is, I say, in this case.
Yes.
So they are the two answers to that,
Okay.
but it's not a proper analysis to look at it in isolation. In the same way that I can't say that, as I say, foreign non-convenience isn't available to me. My Lord, my third point in favour of my argument were essentially public policy concerns, that one is shifting jurisdiction that one would ordinarily expect to be in onshore Dubai to the DIFC in circumstances where both the common law and the UAE Civil Procedure Code tend towards, if I can put it that way, defendant-sided jurisdiction.
Are there any other jurisdictions known to you where jurisdiction can be established on the basis of the citus of the plaintiff only?
In the Dubai Civil Procedure Code itself, that is there as a last resort. Perhaps I can take my Lord to that.
What tab is that?
It's tab 16.
Yeah.
And section page 317.
Yeah.
We've got 2 pages, which is the section of the local jurisdiction of the courts. Article 40 essentially provides claimant jurisdiction if there is no other. So perhaps I can come back to Article 40 when we see how the structure of the jurisdiction works.
Yes.
So Article 31, which is the primary article on jurisdiction, halfway down the previous page. Jurisdiction shall be vested in the court within whose area the defendant has its domicile unless the law provides otherwise, and if no domicile place of residence. So,
Yeah.
default starting point, defendant-sided jurisdiction.
Yeah.
We then see, for example, 31.3, commercial matters, the court in whose area the agreement was made or was performed. So again,
Yes.
that looks fairly common to English Irish law location of the contract.
Yeah.
Article 32, real property, where the property is again what one would expect.
Yes.
So one sees then over the page as well that series of exceptions to the ordinary rule, none of which are surprising. I take 35(1), for example, commercial bankruptcy, where the business premises of the bankrupt is located, obvious reasons for that. Article 36, exceptions for employees. So it's only if you don't come in within any of those that one gets to Article 40. If the defendant does not have a domicile or place of residence in the state, not possible to determine which court has jurisdiction on the basis of the foregoing provisions, jurisdiction shall be vested in the court in whose area the plaintiff has his domicile or place of residence.
Yeah.
So that is an example of claim side jurisdiction, but the point is it's very much the last resort.
Yeah. Thank you.
And so in those circumstances, I say that claimant side jurisdiction is exceptional and contrary to ordinary legal principle, both as a matter of common law, which is based on defendant-based jurisdiction, and as we've seen there, civil law jurisdictional principles. And so when the law comes to construe the article dealing with the claimant jurisdiction, that ought to be borne in mind and carefully construed, and I say that justifies reading it down. So that is they are the two limbs really of my public policy.
Yeah.
Contrary to ordinary public policy and moves jurisdiction exclusively to the DIFC when one would expect it to be applied. They're the two limbs at that point.
Yeah.
Point 4 is a short point, which is, I say, it's contrary to the scheme of the Judicial Authorities Law, which provides under Article 582 for a bilateral opt-out with clear provisions in writing.
Yes.
And also that jurisdiction can be non-exclusive, whereas the jurisdiction of Gateway A
is exclusive.
Precisely.
No.
So when one just runs that forward, if the broad approach to Gateway A is adopted, there's no need for any future claimant to ever agree to the DIFC book jurisdiction rules, because they've always got the unilateral option of coming in. So I say the wide interpretation of Gateway A doesn't fit with the rest of the law.
Yes.
The law should be construed to work together.
Yeah.
My final area of pointiness 5 is absurdity in the sense of statutory construction when one looks at the outcomes of the wide approach. I say the results it produces are anomalous and illogical in the sense that exclusive jurisdiction is conferred for events where there were no connections to DIFC at the time, particularly having regard to retrospective exclusive jurisdiction. I also say it's artificial for there to be jurisdiction in those circumstances. It is futile and pointless. I'm running through the list of arguments on interpretation. I say it's futile and pointless in the sense that there will always be alternative courts available for the result to be determined. This isn't a case where my interpretation would mean there was nowhere for this to be tried.
Yeah.
I say the scheme is unworkable in that it prevents businesses being able to arrange their affairs, and that also one ought to be careful when interpreting this by saying, oh, forum non-convenience is the answer, because that opens parties up to the uncertainty of having to apply for forum non-convenience and the inevitable unrecoverable costs, at least in part, of running the forum non-convenience argument. So the businesses will always be put to the time and inconvenience where one is relying on a judicial discretion or a judicial evaluation of the appropriate forum, which would be contrary to the principles of efficiency. I say that also means it's inconvenient for businesses. And my final point on that is that there is a very significant counter mischief created by the wide interpretation. It would allow extreme forum shopping by claimants to deal with defendants, such defendants who could perhaps operate their business on a basis that's wholly internal to one jurisdiction, reasonably not include choice of court clauses in their transactions. Then the claimants go and establish a DIFC branch to family jurisdiction. And of course, for many, although not all, non-contractual claims, it would be highly unlikely for there ever to be a choice of jurisdiction clause in any event. So those are the 5 reasons why the wide interpretation should not be preferred. Before I move to the case against me, I just want to spend a little bit of time saying why my interpretation is the right one. I say, having regard to the purpose and the mischief of the statute, that the purpose of claimant personal jurisdiction is to ensure that the DIFC courts have oversight of those regulated to carry on business within the DIFC, and, as the Lord alluded to earlier, to offer DIFC court services to those regulated to carry on business within the DIFC. Now, my interpretation is consistent with those objectives. It offers DIFC court services to those in the DIFC. But what I see is that those objectives and that purpose is only properly engaged from the time of registration, and that actually when one weighs the competing issues, there is not a legitimate interest in there being DIFC jurisdiction prior to that moment of registration, because the issues of retrospectivity and accounting mischief of forum shopping are outweighed, or in fact they outweigh any perceived interest in offering DIFC court services to users for matters from a long time ago in the past before they were here. So I say when one weighs those in the balance, my scheme allows these courts to offer the services that the Lord alluded to, while striking a fair balance with the interests of defendants and counterparties. I also said, by contrast, there is a legitimate interest in there being retrospective jurisdiction for defendants for 2 reasons. Firstly, the principle of integrity, essentially ensuring that DIFC entities pay their liabilities. And secondly, the defendant-side jurisdiction is common and normal, so that the issues of interpretation don't arise in the same way. If I can move to the case against me, I have 5 points on that as well.
Yes.
My learned friend, in his skeleton argument, refers to the paragraph 20, says in Corinth, he relies on Corinth to say there's no requirement to demonstrate any other connection. That's just as Chadwick's point. But I've already dealt with that. I'm saying there's a difference between the temporal scope of the personal jurisdiction on the one hand and some kind of transactional link which is properly brought in by B and C on the other hand. My learned friend at 26 of his skeleton argument says the test is whether the DIFC court has jurisdiction. There's no requirement the court must have had jurisdiction at some earlier time. For example, the court may have jurisdiction as a result of a jurisdiction agreement. Well, a jurisdiction agreement is obviously a completely different circumstance to a case of jurisdiction as on right. It's based on consent and agreement. It's dealt with entirely separately in the judicial authorities law. So when one strips out that example from the learned friend skeleton, all we have there is him asserting the proposition that it doesn't matter. So that doesn't take him any further. He refers to the case of Barclays and Afras, where there was claimant-side jurisdiction. 3 points on that. The first point is that there was no timing issue in that case. Secondly, that claim was an additional claim brought off the back of existing litigation, so that's a very different context to a one-off dispute. One thinks, for example, of the necessary and proper party type gateways. Jurisdiction in those circumstances is not unusual. And thirdly, as a matter of fact in that case, the point wasn't argued and the defendant's lawyers withdrew at a relatively early stage in the application. So insofar as one seeks to put any weight on that case, one needs to be cautious that the issue just wasn't ventilated.
Yeah.
The main thrust of my learned friend's point on this is that there is nothing particularly surprising about jurisdiction being established as a result of factual circumstances which have arisen after the cause of action arose. I say it is, if it's such claimant-sided jurisdiction. The only examples he gives are defendant-sided, whether under Brussels or whether under common law. We've looked at the CPC, where we see that claimant-sided jurisdiction is surprising. It's in Article 41 as a last resort if there's nothing else there. So that's the very point. The defendant-sided jurisdiction is normal. Claimant-sided personal jurisdiction as of right is surprising and unusual for very good reasons of policy arising out of the need to avoid forum shopping. And so when one looks to interpret it, one needs to be very careful about exorbitant claimant-sided jurisdiction. And my learned friend doesn't address that point, because all he deals with is defendant-sided jurisdiction. The Dubai World Tribunal case he refers to, again, it's a defendant, and it's the equivalent of the defendant leaving the jurisdiction. It was within the jurisdiction of that court, then it became no longer connected to the relevant company, and so the jurisdiction fell away. It's as if the defendant moved. So there's nothing in that point. My learned friend's suggestion that there is an uncertainty here is ill-founded. One regularly determines, as we do in this case, questions of time on the pleaded case. You know, these issues will always be determined on the case as pleaded by the claimant, and that will identify a relevant date. And all courts, including these courts under gateways B and C, will be perfectly capable of determining what the relevant date was.
Yes.
My Lord, that's everything on jurisdiction as of right. Abuse are essentially the same points. I'm not going to repeat them, but I
I wonder if you could help me on that.
Yes.
There's the most early authority of this court. I think the judge was the late Justice Sir Anthony Coleman, who, when finding there was no jurisdiction on the facts, where I think it looks as if there had been a party had been wrongly named in the proceedings. But in respect of the claim against that party, there was a lack of jurisdiction because it was simply abusive to drag them in when there was no basis for dragging them in. I'm doing my best to recollect I think your opponent referred to this authority in another case some time ago. And that's the only case I'm aware of where the notion of abuse of process has been identified as being relevant to jurisdiction. Are you able to help me with this case I'm drafting to try and recollect?
My learned friend has it in his fingertips. He's got it recently.
I can help with it.
Yes, well,
now's a good time. I think your Honour's referring to Hart Down.
that's right.
It wasn't so much an abuse of process argument, it was a jurisdiction argument. What had happened was that there were a number of defendants,
Yeah.
and the claim was advanced, was articulated against one of the defendants, which was not a central establishment or a DIFC establishment.
Yeah.
But what was being said was because there were other claims on the claim form, which were, at that stage,
Yeah.
central establishments.
Yeah.
Nevertheless, the court had jurisdiction over the
On a
entirety
sort
the
of
claim.
necessary parties or basis.
It wasn't argued in that way.
Not
but
argued
nevertheless-
in that way. Somehow or other he was swept in, or it was swept in with the others when there was jurisdiction.
Correct, but the way that the case was dealt with was simply to say that it's not sufficient simply to put a defendant on a claim form. And what one has to articulate a claim against the defendant in order to meet the requirement of
I
Article 5.
that's right.
I had tried to develop that in the proclivity
Yes,
case, which
yeah.
is the one that you're
Yeah, you
referring
didn't
to.
get anywhere with that.
I didn't get anywhere with that.
Yeah.
I tried to expand it out into a prospect
Yeah.
of success, but
Well, thank you very much
shot down
for
length.
blowing the fog and mist that had descended on, in my memory, on that case. That's right. Now I remember it, and none of that arises here. So by abuse of, thank you very much. So abuse of process. Well, tell me, what do you mean by abuse of process as some concept distinct from FNC?
I mean that would be a reason for these courts to decline jurisdiction regardless of any other form. In regulating its own processes, this court should decline jurisdiction in circumstances where a claim is being brought that brings a defendant to this court in a way of which the court disapproves.
Regardless as to whether or not there is an alternative jurisdiction, where there would be jurisdiction for the claim.
The availability of that would necessarily have to feed into the analysis, because one could see the court may be much less likely to find that a claim was abusive if there were nowhere else for it to be brought.
In other jurisdictions, for instance, in England, where the defendant is outside the jurisdiction, there's the hurdle of a good arguable case. But are you able to give me any examples from any other jurisdictions which are about which we have some common knowledge, where abuse of process could be a relevant consideration in deciding whether to accept a case or not, as distinct from having to show a good argument case?
No. I'm conscious I'm trying this from first principles on abuse, which is why I refer back simply to Gorwood and saying this is about ensuring that processes that are literally legitimate should not be permitted.
See, when the court in England exercises a jurisdiction over a party who was not served within the jurisdiction,
Yes.
it exercises a discretion. Jurisdiction in those days is not established ex debito judicia. It's still a matter for the discretion of the court as to whether to find that jurisdiction has been established. But none of that features on the DIFC scheme, does it? Apart from forum non-convenience.
Well, that's the point. The question is whether it does or not. There's no express reference to forum non-convenience.
Yes.
And yet, the DIFC courts have been conscious of the potentially wide application of
Yes.
and so use FMC
Yes.
to ensure that doesn't arise.
Yes.
Now, it's a
So
difference.
you say there's an inherent jurisdiction point here. One example of the exercise of that jurisdiction is FMC,
Yes.
and an analogous consideration called abuse of process
Exactly.
can also fall within the inherent jurisdiction of the court.
Yes.
Yeah.
And that arises from the court's power to regulate its own
Yeah.
procedure.
Yeah. All right. Well, now you tell me why distinctly. In fact, I don't think you do. I think you say that all the reasons that you rely on forum non-convenience are your reasons for saying that it's an abusive process. So the question I have for you is this. If you're unable to succeed on forum non-convenience grounds, speaking hypothetically, is there any room here for the operation of the concept of abusive process? Because if there isn't, I might just only hear you, might as well just hear you on your forum non-convenience argument.
I'm not going to say much more about abuse. I don't see anything extra. I do say there is room, because I say it is open to this court using the inherent powers that we talked about and the power in the rules to prevent abuse of process happening. That it is open to the court for all the reasons I've said, that even if there is titular nominal jurisdiction, that it's open to this court to define that.
So really the difference between abusive process and forum non-convenience is that abusive process will not necessarily focus on whether there is a better alternative forum. It will simply focus on whether it is right that the putative, if jurisdiction were established in the putative forum, it would be an abusive process for that to happen.
Yes.
So really, it's more your construction arguments that feed into abusive process than your forum non-convenience arguments.
Absolutely.
Yeah.
Yes. Sorry, I ought to have made that clear.
Yes.
It's everything I say why this is wrong and startling to matter of
Yes.
construction. I say if I'm wrong on that, well, I just move them over lock, stock and barrel and say, well, if there is putative jurisdiction as a matter of construction, in these circumstances, for there to be such jurisdiction, would be sufficiently vexatious to amount to abuse of process.
Yeah, I follow.
For example, if the DIFC court has jurisdiction, onshore Dubai wouldn't be available for my fund.
Yeah.
That brings me to forum non-convenience, where I do take different points. It's common ground between another friend and I that one's essentially applying the Spiliada.
Well, this court's decided that that's the
Yes.
that's the doctrine of FMC that's applicable here.
So I say that England is an available and significantly more appropriate forum for this dispute than the DIFC. And I say that England is better for 5 reasons. First, the relevant legislative...
You'd accept the jurisdiction of the English court, would you?
Yes.
Well, you'd have to implicitly undertake.
My Lord, I'm prepared to expressly undertake. I've got instructions to expressly undertake if required to accept the jurisdiction of the English courts.
Yes, and England's a better forum.
So England's a better forum. One, it was where the underlying performance occurred in the sense of the placing of the share order. Two, the subject matter of the dispute, the SAB Miller shares, were on the London Stock Exchange. Three, and this is the big point really on which I rely, it is likely that FZCO issues are going to arise.
Sorry, which issues?
The Financial Service and Market Act
issues,
FZCO
issues,
which my Lord, I'm sure will know better than me, is a complex and technical statute.
Yes.
And source books arising and matters of those sorts, such that that is a complex local regime that I say the English courts are substantially better placed to deal with than these courts.
Well, we had a go at dealing with it in a major piece of litigation involving some Swiss banks.
Yes.
So we're not completely uneducated in that area.
No, I'm not. This is I'm weighing this in the balance, and I'm saying where issues of local legislation arise, that points towards England.
Right.
So I say when one looks at all of that, the real and substantial connection is with England. The only pleaded actions of my clients were the alleged email communications. Well, they're neutral because they're between the two parties set in their different jurisdictions. And secondly, the non-payment of the sums owing. Well, insofar as that not happening occurred anywhere, it occurred in onshore Dubai, so it doesn't point to the DIFC as more appropriate for it.
So trades are executed, but you say they weren't executed pursuant to any agreement by your side. Common ground, your side didn't pay on settlement. The only question is whether the executed trades were executed pursuant to an agreement that they were to be executed on your client's behalf or for your client's account.
Yes, I'm not sure, and I don't have instructions on whether or not I would admit that trades were placed. I don't think we know that. I think we might put us proof on that. But for example,
yes, all right.
Yeah, the broad
all right. But let's assume that that's relatively easily established from the documents.
I'm just conscious not to affect any case.
The only question would be, well, was there did the appropriate underlying contract consent? That would be the question for the court. Whether your side entered into an agreement that and requested this trade for their account.
Subject.
I mean, it could be decided in a day.
Well,
in this case.
Subject to any issues arising over
FZCO and all that.
protective legislation, if I can put it broadly like that.
All right. Yes. But the witnesses would have to go to London unless there were the court agreed to video link evidence.
Yes, well, my clients have already undertaken to prepare to undertake to submit to the jurisdiction.
Well, that's different from actually as to how the trial would develop.
And claimant side of witnesses that this is an English company.
Yeah. Well, they're there in London, you say.
I say.
Yeah.
Or if they happen to be working more in Monaco than in London.
Yeah, they can jump on a plane. Not on Ryanair, but they can jump on a plane.
EasyJet from the East Coast.
EasyJet, yeah.
So I say when one looks at that centre of gravity, it's at least neutral. And I say, if anything, points towards England in terms of locations of their witnesses. And
Yeah.
just going back to the issue about the contract and appropriate jurisdiction, both under the Brussels regulation, for example, and CPC, what one looks at place of performance of the contract, and I refer to the Brussels regime. The issue is one of characteristic performance, so it's not the jurisdiction of the party who's simply paying the money. It's the party who's providing
You're
the service.
consenting to the
Yeah.
jurisdiction.
No, but I'm saying when one is trying to weigh on an FNC basis where the balance lies, if one looks at these other regimes, they point towards the place of
Yes,
actual performance.
Yeah.
And that place of actual performance here is England.
Yes.
By contrast, there is no relevant connection whatsoever here with the DIFC. My learned friend conflates repeatedly such links as my client have to onshore Dubai with the DIFC. And that is a very elegant illusion, but it's not right. There's no connection to these calls at all on the underlying facts. And so in those circumstances, when one asks, is it the DIFC or is it England that is more closely connected, there is only one jurisdiction that is more closely connected, and I say that's plainly England. My learned friend raises various issues that he says makes the DIFC more appropriate. If I could just run down those. He says the claimant has a branch in the DIFC. Well, it's an English company, and I would say that the company trumps branch. It's obviously working out of England, and it's an English located company. Secondly, the witnesses travel regularly to the DIFC. Well, we've covered the travel point. Defendants appear to be based here. There's no hardship for my clients. Well, we're not taking that point, and we're prepared to submit to the jurisdiction. The written evidence is unlikely to be voluminous and available electronically. Well, that's really a neutral point. That doesn't go one way or the other. And enforcement against parties based in the UAE will be simpler if a judgment is issued by the DIFC courts. Well, that's setting up a false problem. First of all, he says it's simpler. He's not suggesting that enforcement is a real problem. The law will be familiar with the memorandum, for example, between the DIFC and the English courts. I say enforcement would work, and so actually this isn't a factor that the court should give weight to, and should, in fact, be outweighed by the other factors. So that is everything on forum non-convenience. I've deliberately left to last the issue of the terms and conditions of the jurisdiction clause. We see on the claimant's pleaded case, this contract that they say was agreed shall be referred to the High Court of Justice in England, the exclusive jurisdiction of which each party hereby irrevocably submits. Now, applying ordinary principles, the courts should defer to that exclusive jurisdiction clause except in extreme circumstances. One thinks, for example, of Donahue and Armco type cases where there are a multiplicity of defendants, where there are jurisdiction clauses against some but not others, where there is a risk of inconsistent findings on integral issues of honesty or other important findings of fact, such that one would want to disregard the jurisdiction clause. That is not this case. This is a simple, relatively straightforward two-party case, as my lord has already indicated. Perhaps if I could just direct my lord to one of the DIFC authorities dealing with opting out of the jurisdiction, which is the Al-Kharafi case, paragraph 89 onwards. It's behind tab 1 of the authorities.
Yeah, wait a moment. Yes, paragraph 89.
So there's a heading, was there an effective opt-out? It then deals with 5A3 of the JAL. CFI may hear and determine when its jurisdiction if the parties agree in writing submit to the jurisdiction.
Yeah.
It then notes at 90, this does not provide in terms for an opt-out. And then it goes on to explain at paragraph 91, the absence in Law 16 of an explicit right to contract out of DIFC jurisdiction is probably best explained by the existence of Article 31 of Law 10. A submission to the court of a jurisdiction of contract shall be effective. That is then analysed at 92 before the important conclusion at 93 that it follows that this court can recognise an opt-out agreement notwithstanding that the exclusive jurisdiction provisions in Article 5A would have conferred jurisdiction on the DIFC courts. Now, I suppose I ought to note that in this case there were extensive expert reports on the principles of prescription under Swiss law in circumstances where the law and jurisdiction of this putative contract is English law. This court does not, in my submission, need that.
Yeah.
And it's hardly surprising that when a claimant with carrying on the business that the claimant does in this case on the English market would have standard terms and conditions, and that those standard terms and conditions would refer to its obligation to comply with FSA rules, its regulation by the FSA, and accordingly to provide for English law jurisdiction. Because this completes my point, if you like, that the centre of gravity of this contract and the forum in which all these matters ought to be determined is England. Not least because on the claimant's case the parties have agreed to it, and there is no reason for this court to withdraw from that position. My Lord, I might just have one vote. My Lord, nothing for now, although I'm conscious, of course, of the learned framework.
We'll have a break now, 15-minute break, and then I'll hear you. I hope very much we can conclude this by 1 o'clock or shortly thereafter, but we'll see how we go.
All rise.
Your Honour, I'll deal with the three heads in the same order, if I'm friendly.
Yes.
If that's helpful. So the first question is, does this court have jurisdiction at all over this claim?
Yes.
Not over a cause of action, but over the claim, because that's how it's defined. And we'll look at the judicial authority law, because my learned friend took Your Honour to it very briefly, but we didn't really focus on the language of it at all in his submissions. But I say, frankly, that it's a pretty straightforward question. If one goes to the judicial authority law itself, which we find in tab 20 behind volume 2.
Yes, just wait for a minute, please. Yes.
So the gateway on which I rely is Article 5A1A. The test for this court is the court of first instance shall have exclusive jurisdiction to hear and determine civil and commercial claims and actions to which the DIFC or any DIFC body, DIFC establishment or licensed DIFC establishment is a party. And the two features of that, which I would direct you on to, are firstly, present tense is a party. And I will say, supported by authority that I'll take you on to, that means that the question for Your Honour is today, is a licensed DIFC establishment a party to this claim?
Yeah.
Everybody agrees that it is, so the test is satisfied.
Yeah.
That's all.
Yeah.
And
the beginning of the end of it.
That's the beginning. Yeah. And I'll try not to labour my submissions, but hopefully perhaps support them with a little bit, both in this jurisdiction and elsewhere. I won't go through all of the authorities that we have in the bundle, but really that is the beginning and the end of it. The second point that I would make just on this is that the text defines that it states a DIFC establishment is a party. So it doesn't distinguish between claimants and defendants. And that is a problem for my learned friend, because he accepts that the jurisdiction in which one must bring a claim against a defendant may change with the status of the defendant. So we have the Lugano Convention situation. If the domicile changes, you have to follow the defendant to the court of domicile. And he says, well, that's acceptable and consistent with international practice. Nothing wrong with that. Well, the problem for him, though, is that this law treats both in precisely the same way, so one can't distinguish between the two. As I said, I'll develop those particular points briefly, if I may. But everybody agrees that the claimant is a licensed centre DIFC establishment. So there's no argument about that. The definition is in the statute, and I don't need to go to it because it's effectively agreed. And as I say, we know from the Corinth case, and again, my learned friend's taking me onto it, so we'll get back to it. We know from the Corinth case that there's no other transactional requirement. My learned friend says, well, he doesn't accept that there's no other connection required. But the point that's being made in Corinth and in those passages of Corinth by the Chief Justice was that one can satisfy that test, and that is the end of it. There is no need to satisfy any other test.
So it was put very tersely by Sir John Chadwick.
Yes, quite. And of course, that claim, the Corinth claim, was a claim against a defendant. And so my learned friend points out the passage where the Chief Justice says, well, this doesn't decide the position in relation to a claim by a defendant. But in the very same case, we have a decision of Sir John Chadwick, Justice Sir John Chadwick, where he considers the claim that was then brought by Barclays Bank against Afras. And I'll just show you one of that, because my learned friend tries to deal with it. He does it in ways which just don't impact on the reasoning. And it's behind tab 4 in volume 1. But can I just describe what the case was? Because the factual background is precisely the same, because it's the same case. So what had happened was that Corinth Pipeworks had entered into a contract with Afras, this third party. This is the third party defendant, the additional claim defendant. And originally in that claim, Corinth produced pipes, as one might expect, and was to deliver them to an end user. And so Afras was going to be an agent originally, but inserted itself into the contractual chain. So that meant that the payment obligations were from the end user, the end receiver of the pipes, to Afras, and then Afras would then be obliged just to pay that money, most of it, to Corinth in that contractual claim. And of course what happened was that Corinth delivered the goods to the end user. Afras allegedly received the money and then did not make the payment on to Corinth, so kept the cash. And so in the main claim, what had happened was that Afras had told Corinth that it had money in its bank account. It was all ready, but there was some block on the account, and so on and so forth. And so in the main claim, the claimant Corinth was looking for a defendant with deep pockets, and so asserted a claim against Barclays Bank on the basis of, amongst other things, conspiracy related to these representations about what was in the bank account. And so it was Barclays' involvement in all of that which was the basis for the main claim, Corinth versus Barclays Bank. And so what was happening in the additional claim was Barclays, of course, was saying, well, okay, if we're liable for any of this, then Afras is the main culprit and must also be liable for this, and therefore we have a part to claim in the additional claim against them. And so that's the context. It's precisely the same factual basis for the original Corinth decision. So then we have this decision on jurisdiction in that additional claim. And the way that Sir John Chadwick dealt with it, we start at paragraph 5, deals with it very tersely as
Where was AFRAS domicile cited?
that's a good question. They were definitely active in Dubai, and so the argument was between DIFC and Dubai courts. That was the argument.
Yeah.
And at that stage, we didn't have the benefit of the Allianz case, so there was no, but no for non-convenience argument was actually run in the decision.
Yes. Paragraph 5.
Paragraph 5, yes. Yes, sorry, I'm pointed out to paragraph 2 of this, which does make the point at about the middle of the paragraph. AFRAS Limited is a company with headquarters in Jebel Ali, Dubai.
Yes. Thank you.
So paragraph 5, for the reasons set out in the judgment, so dealing with the main crimes judgment.
Yes.
The Court of Appeal came to the conclusion that the bank, which was registered in the DIFC and licensed to conduct business there, was a licensed DIFC establishment, and so was subject to the jurisdiction of the DIFC courts. But if the bank is subject to the jurisdiction of the DIFC courts, it must follow that the bank can invoke that jurisdiction. The law has effect not only in relation to a proposed defendant, but also in relation to a proposed claimant. Barclays Bank plc is a licensed DIFC establishment, as the Court of Appeal has held. It can be both claimant or defendant to proceedings in this court. Further, given that the law provides the DIFC court to have exclusive jurisdiction, it cannot be a party to proceedings in Dubai civil courts. So it's simply wrong. And then it's paragraph 10.
But there are no temporal questions.
No temporal question here, that's correct, and I'll come on and deal with that.
Yeah.
But this suggestion that one can distinguish this claim on the basis that this is dealing with an additional claim just doesn't work, because there's no reference to a necessary and proper party test, which doesn't feature in the jurisdictional requirements of this court. It is in England, but it's not a feature of this court.
Yes.
And so my friend made 3 comments on this case. He says, yes, it's not a timing issue point, and I accept that. I'll deal with that in a moment. But the fact that it's an additional, dealing with an additional claim is not relevant to the way in which the claim was decided. And he says, well, and then he says, well, it wasn't argued, the point wasn't argued for the defendant. I just simply make the point that this Deputy Chief Justice John Chadwick, who decided this, he obviously applied his mind to it, and he had just recently sat on the Court of Appeal when they were considering these sorts of issues. So there's really nothing in the point that this case might be wrong, because there are other points that might have been taken on that. But it doesn't deal with the timing point, and I'll come on to that. So the issue on that front is, what is the correct moment at which to determine whether the test for jurisdiction is met? That seems to me to be the issue. I've shown you on the legislation which says yes, it's present tense, and that I say is the end of it. But the court has also addressed this court has addressed this in 2 ways. The first way was in relation to change of legislation. So the legislation changed in both Karachi and Corinth between first instance and appeal. And so the question which arose for the Court of Appeal in both cases was, which legislation do we apply? It's a slightly different aspect of the problem, but it is the same problem. When do we deal with this test? And in both cases, the answer was we apply the new legislation. And the discussion deals with the retrospectivity of that legislation, and the main discussion is in the Karachi case. If anyone wants to look at it, it is at...
Well, I read it very recently.
It's paragraph 6 of that, which deals with it. So yes, that case is dealing with a change in the rules for jurisdiction, but the point is the same, because the case confirms that what matters is whether the claim fits within the relevant legal test at the time when the test is being applied. So different from, say, the Lugano Convention situation in England, where the test is applied at the date of issue of proceedings. So the question for Your Honour is simply the one that's stated in Article 5A1A. Is the claimant now a DIFC centre establishment? Now, my learned friend has pointed, has referred Your Honour to the case of Seren. This is another case in which this was addressed, at least dealt with. one way or another. My learned friend took Your Honour to some passage of that, but there are others which are helpful on this very issue.
Yeah.
In terms of tab 8, this is a decision of His Excellency Justice Shamlan.
Yes.
Now, Your Honour was taken to paragraphs 13 and 17, but if we start at 9A, we see what the issue was that's being determined.
9A, yeah.
So there's a previous decision that the court lacked jurisdiction, and then at 9A we see the grounds of appeal submitted by the appellant are as follows: that there has been a material change in circumstances since the STT hearing, as the respondent registered a DIFC branch of their firm on the 16th of December 2015, and therefore is now a DIFC establishment. So that was the ground of appeal. Again, so a change of facts, not a change of legislation.
Yes.
So how does this Justice Shamlan deal with this? Paragraph 11.
Yeah.
He says, in light of the material change of circumstances argument pursued by the appellant, it is my opinion that the main issue here is to determine the proper interpretation of Article 5A1A, namely, whether the current status of the respondent satisfies the definition of a DIFC body, DIFC establishment, or licensed DIFC establishment.
Yeah.
So the current status was the test. In that case, the test was not met. There's no
Didn't
question.
satisfy the definition.
The definition of registered, precisely.
Registered.
Yes.
Yeah.
So he decided in this case that the test to be applied was the current one.
Yeah. Yeah.
So the idea that the court has never really considered this temporal aspect is, I would suspect, wrong. And it's right that in that case he decided the test was not satisfied, but as a necessary part of that decision, you have to look at when this needed to be decided.
And both Barclays and Afras and Sheridan are subsequent to Horrocks.
Correct. They're first instance decisions, and if we follow the English stare decisis, then Your Honour would need to decide that these decisions were plainly wrong in order to depart from them at this stage. And I'd suggest that they're not plainly wrong. And we see the passage at 17 that Your Honour was referred to, where the judge says, it may be that the question of jurisdiction could be revisited if and when the respondent successfully registers as a DIFC establishment in the future, as mentioned above. Now, how far that goes is not a question for today. And it may well be that this timing issue is constrained by the rules. The rules require jurisdiction disputes to be raised at particular moments in the proceedings. So it may be that the rules would not permit, for example, a sort of 11th hour, day before trial, change of jurisdiction. But that is not the question for today. The question for today is, well, when does Your Honour have to be satisfied that the test is satisfied? And the answer is very clear as today. Now, the closest that my learned friend gets to actually engaging with the language of the legislation is in his skeleton argument of paragraph 26.5. Heard much about this.
26.5.
26.5.
Yeah.
So he says, as to the literal meaning, he says the judicial authority law is silent on temporal jurisdiction. And then he says the literal meaning therefore gives no clear indication as to from when the jurisdiction is engaged. However, the definition of licensed DIC entity, by reference to words such as licensed, registered, indicate the key temporal trigger of jurisdiction is the time of registration or license. Well, there's just nothing in that. The use of the past tense is registered. It's registered. The use of registered means that at some point prior to the assessment of whether jurisdiction is founded, it exists, there must have been a registration, but that will always be the case. The question, though, the point about that, about the literal language, is the present tense is registered. And it's very clear that the literal language points to today. And as I've said, that's how the courts have addressed it in correctly current and stuff. So my learned friend's approach is to try to rewrite that statute. And I've come to his proposed wording in a moment, but I suggest that the whole exercise that he tries to undertake by reference to not being able to organise your affairs, public policy issues that he describes, is an impermissible exercise in the first place. Because you can't, it's not for this court to rewrite legislation in the way that he thinks is appropriate, even if one accepts the criticisms that my learned friend makes of the conclusion that leads to. My learned friend...
It is a matter of general law relating to interpretation.
Correct.
There are occasions when a particular interpretation leads to a consequence which the court regards as absurd or a highly unlikely intended consequence.
Correct.
And that can have an effect on the meaning that is ultimately given to the words in question. That's
correct, yes. So so my learned friend relies on effectively the strained construction, and he recites, he refers in this an argument to the frontline developments case where that is examined in this court. But what I want to show you on is that principle has its limits, and those limits are very apparent from both frontline and also from the English case law, which develops the scope of that rule.
Yeah.
If the natural meaning of the words cannot bear the interpretation that is being imposed on it, then that's the end of the matter.
Yeah.
One can't just say, well, we don't like this, or even if it turns out to lead to real problems, that is what we're stuck with. So can I just show you on a very brief those passages? The first is frontline developments, then my learned friend relies on that. Tab 10. So just to introduce this case, if I may, this was an issue. There was an issue in this case about a provision of the employment law, Article 18 of the employment law.
Yes.
And that imposes a financial penalty, I'll call it. There's an argument about what it really was. But if an employer fails to pay the employee everything that's due within 14 days after terminating the contract of employment, then the employer is liable to pay a penalty.
Yeah.
And in effect, he has to continue to pay the wages until he comes up to date with what's due. And so the argument that was being run was that a literal interpretation of the statute would be unfair, would be absurd, and the sort of points that were being made.
Yeah.
What if it's about the dirham unpaid? Well, then you have to keep paying the wages, and then of course you're now a day behind on what's due, so then you have to keep paying until you pay that.
Yeah.
And it might take a long time to resolve it. Just all those sorts of arguments were being run. These are absurdities.
Yeah.
And one could see the list of absurdities that was alleged on page 98, paragraph 26. I won't take you on through them, but it's all there. And just to pick up at paragraph 29, if I may.
Yeah.
So this is Justice Tunzaki Azmi.
Yes.
Is that right? Paragraph 29. However, I'm ultimately still faced with the problem of how to interpret the legislation in the way the appellant submits to be fair to an employer if any of the situations mentioned in this. Unfortunately, I cannot replace the words impugned or read, or read into the provision one or more words, or delete from the provision a word or two. As Article 18 stands, it is grammatically correct, makes sense and clearly understandable. The only complaint, if at all, is that it can create situations which the employer considers to be unfair to him. That is what the legislator intended by the use of those words, drafted in the manner it does. It is not for this court to give any other interpretation, no matter how sympathetic this court may be to the employer. My learned friend then cites paragraphs 30 to 31, which deals with the various canons of interpretation, including the golden rule, the plain meaning of an enactment must be followed, and then refers to, in effect, the strained construction rule, which is in paragraph 31. And then if I could just ask you just to read paragraphs 32 to 34, rather than me reading them out.
Yes.
So the principle is you can't redraft statutes to deal with these situations. One has to apply an interpretation that the words can bear.
Yeah.
And that's wholly consistent with the position in, for example, England. And I've cited, or I've inserted into the bundle, the Prince of Hanover case, where that was an example of somebody trying to do that. I won't show you on very much of it, but if we can just go to volume 2, tab 29. There was a specific point in that case, was the extent to which a preamble could affect the interpretation of the statute. Because the preamble contains very often the purpose of the statute, and so it could be a legitimate aid to construction. And in this case, there was an act which conferred British nationality onto Queen Anne's daughter, and that was Princess Sophia, and her issue.
Her father was Danish, wasn't he?
That I do know.
Yes, Queen Anne's husband was Danish.
I see. So that might have been the reason for the act,
Yeah.
having been and so the act referred to nationality being conferred on all persons linearly descended from Princess Sophia. And the argument was that the effect of the act, nationality, would only be conferred on those who had been born during the lifetime of Princess Sophia. And in part it was said that was because that's what the preamble seemed to suggest. That was the purpose of the legislation as indicated by the preamble. And so if we go forward to page 467, you can see what the House of Lords said about that. Towards the bottom of the page, it has that.
Yeah.
So you want to have the courts, about 5 lines up, courts are concerned.
Courts are concerned, yes.
With the practical business of deciding a list. And when the plaintiff puts forward one construction enactment and the defendant another, it's the court's business, in any case of some difficulty, after informing itself of what I call the legal and factual context, including the preamble, to consider in the light of this knowledge whether the enacting words admit of both the rival constructions put forward. If they admit of only one construction, that construction will receive effect, even if it is inconsistent with the preamble. But if the enacting words are capable of either of the constructions offered by the parties, the construction which fits the preamble may be preferred. So that's even dealing with a situation where the purpose is recorded in the legislation. You have to start with the actual words and decide what they can bear. If we turn forward one more page, 469, towards the bottom.
469?
Yes, please.
Yeah.
This is Lord Morton's speech. The final paragraph, my lords, to my mind, the Attorney-General is faced at the outset with one great difficulty. His argument really amounts to an invitation to your lordship to perform a surgical operation on the enacting part of the statute by inserting immediately after the words born or hereafter to be born, the words in your majesty's lifetime. Now, if the legislature had intended to limit the class of persons to be naturalised, I can think of no reason why these words should not have been inserted. About halfway down, second paragraph, but the second sentence of that. In the face of these words, I find it hard to imagine any context or any circumstances which should persuade your lordships to perform the surgical operation already mentioned, and the matters upon which the Attorney-General relied fall far short of persuading me to perform it. And then, just for completeness, Lord Somerville at 474, in the middle of the page. If, however, having read the Act as a whole, including the preamble, the enacting words clearly negative the construction which is sought to support by the preamble, that is the end of it. And the test he describes over the page at 475. Coming to the Act, I therefore accept the appellant's submission that the preamble and enacting words should be read before deciding whether the latter are reasonably capable of the meaning which the appellant seeks to place on it. See, Your Honour is not interpreting a contract. Quite different principles apply. There's no scope for implying terms. And the starting point is the words of the legislation cannot bear the meaning that it is contended for. So what is the meaning that my learned friend contends for? And we see that, we didn't hear much about it today, but we see it in paragraph 23 of the skeleton argument. And he says, in relation to claimants, the legislation only gives personal jurisdiction over DIC claimants for claims in respect of material facts that occurred after their registration.
Yeah.
So we're rewriting the statute. And there are a number of immediate problems that arise here. I say, there's just no way to get to that meaning on the face of the words that Your Honour has to apply. But there are some real problems with this. In part of my learned friend's submissions, he says, well, his interpretation gives the clarity, gives certainty. Material facts is a major part of his case. And that focus on material facts just can't be right, it seems to me. Because when did the material facts for any dispute arise? Well, there's going to be a variety of different dates. In any case, just take a breach of contract case. You're going to have the date of the contract. You're going to have the date of the breach. That's when the cause of action arose, but that's not the latest date of the earliest date of material facts, because the parties would have contracted. You're going to have the date of the loss. You may have pre-contractual dates. What if the party alleges a misrepresentation? That's a material fact. The date of that, you have to take it back to there. And we'd end up, in this court, having a long debate about what is or isn't material. Now, no doubt that would be a gift to the lawyers, but it doesn't help certainty. The second point, my learned friend alluded to my point on this, is that this court would have to establish at this stage of the proceedings when those material facts arose. Can't be enough.
Sorry to interrupt.
Yes, of course.
On the facts of this case,
Yes.
nothing capable of answering the description of material facts occurred prior to the registration of the
After.
branch. Yeah.
I think if Your Honour means after, I think I would have to agree with that. Because
Yes, I'm sorry.
Yes,
I mean,
yes,
you're right.
yes.
I
No,
mean,
I
after.
accept
No.
that. I accept that.
So we don't have that difficulty here.
No.
What you're saying is that if his interpretation is right and is generally applicable,
Yes.
then you can have these difficulties.
Yeah, and we're dealing with a piece of legislation, a pretty fundamental piece of legislation for this court. So if Your Honour's decision today was, yes, my learned friend's correct, his interpretation is correct, the material facts must arise at a time when the claimant is registered, well, then Your Honour will be opening up this jurisdiction to all kinds of, we'll have even more jurisdictional debates than we already
But what about
encumbered with.
if that were refined to the accrual of the cause of action?
Again, we're going to, so that is a test which applies, for example, to limitation questions.
Yeah.
And very often, one has a trial on the issue of limitation. Sometimes as a preliminary issue, it's taken, it is a trial. So the result would be trials on issues of those sorts to determine jurisdiction.
But just taking the English position by comparison, there can be disputes as to where a contract was made,
Correct.
gateways relied on, or where the damage from tortious conduct was suffered and so on. And although sometimes that can lead to some heavy litigation, generally speaking, it's almost always decided on affidavits
Yes.
and the documents.
And the reason for that is because in those sorts of environments, the court deals with it on the basis of good arguable case. So you have to show you have much the better of the argument. It's not just done with pleadings. One has to show one has much the better of the argument that you fall within the jurisdictional gateway.
Yeah.
But in this case, what my learned friend contends for is a test according to which the material facts must have arisen after registration. And so one can see it's just going to be open for abuse because who bears the burden? For example, say in this case, we have a contract and it's been entered into before, after registration. So it's a different case. So we have registration and after registration, the contract's entered into. Can it be right, the defendant can simply assert at that point that there was a material misrepresentation which occurred sometime previously, and that would change the solution. So it can't just be about allegation. And then the question becomes, well, who bears the burden of that? Because in that situation, the burden of proving, establishing that there is jurisdiction would be on the claimant in circumstances where there's this allegation, counter-allegation by the defendant. So all of those sorts of questions, all of those problems would need to be resolved. We need to find a solution to how we address all of those situations. It's not quite as simple as simply saying, well, we'll take the English approach, because the English approach is dealing with causes of action arising where there's a body of law. So yes, I can see if the position might be slightly different if the question is cause of action, but that is not the way to put one.
So you take his argument to involve the proposition that it must be proved to the point of final determination rather than arguable case or better than...
No, that's not how you put it.
No, but you isn't the submission you've just been putting to me predicated on your opponent's case being that it must be proved to final determination that all the material facts had occurred after registration?
No, I don't think I need to go that far. I'm pointing out
Well, he
problems.
doesn't suggest... I heard no argument as to whether the establishment of his necessary condition, that the material facts that occurred after registration, was anything other than a final determination of that matter and not decided on some lower test as to arguability or better of the argument.
It may be my fault. I'd heard my learned friend say that one doesn't decide it on the pleadings, is the way that he put it, on the basis of the allegation. So he has not, as I understand it, proposed any other tests other than that simply the facts be alleged. That's what I heard, but it may be that I misheard.
Oh, I see.
But I don't know what other tests might be applied. But my point is simply that the allegation test, when you put it like that, can't be the right one because it's far too open to manipulation.
Yes, I follow that.
In any
You
event,
assume that his approach is simply as a matter of allegation on the pleadings, on the claim form.
yes. and then I take it further. So I say, well, assume that that's wrong, and so we perhaps mitigate that a bit.
Yeah.
What then is the test?
Yes.
Is it good arguable case?
Or is it final determination?
Well, and how is it? It won't be final determination, because then one's having trials at the jurisdiction stage, which has never been the way in which any court, as I'm aware, has approached these sorts of issues. Certainly not this one, certainly not the English courts.
Yeah.
So then, and there'll be all kinds of questions about.
But your main point about where do you draw the line as to what's material and what isn't?
Yes. Well, that's one point. Yes.
Yes. All right.
What counts
One
as
of your
what
points
isn't?
is that point.
Yes.
And that would apply, in a sense, whatever the
Regardless.
level of determination is.
Correct. My secondary point was the one that I've been
Yes.
articulating. I see that there are responses, and there may be ways in which the court could deal with that, but it
Yeah.
involves a much more involved situation than the one that I'm proposing,
Yes.
which is simply, as of today, is the
So you just go to the register
one looks at the document, the one-page document,
and see
it's
what the
printed
date
out.
is.
Correct. So the idea that there's certainty associated with my learned friend's interpretation seems to me to be very difficult.
I understand.
And the third problem I point out, and I've alluded to this previously, is simply that my learned friend says that this limitation, this temporal limitation, applies only to claims made by licensed DIFC establishments. So he accepts, as I've said, that there's nothing wrong with jurisdiction changing on the basis of facts associated with the defendant, facts within the control of the defendant, if I can put it like that. And he accepts that that's perfectly fine. And I've mentioned the Brussels and the Guardian Convention work in that way, and the Canada Trust and Stoltenberg case deals with that. The question is decided at the date of issue of proceedings. So if that changes after the contract, after the end of the expectations of the parties, and in that case the claimant, will be confounded. My learned friend says there's nothing wrong with that. And I say that presents two difficulties. And the first is the point that I've already made, which is that on the language of the statute, one can't distinguish between claims by and claims against. But the second point is that if there's nothing wrong with jurisdiction changing because the defendant's status changes, then why should there be anything wrong with the jurisdiction changing because of a change in the claimant's status? Why is it that the defendant's expectations are so much more important than the claimant's expectations in this regard?
And he doesn't submit that the judicial authority law is ultra-virus.
No, I think that would be a difficult argument, at least in this court. But I would hesitate to put ideas into the defendant's heads in these sorts of situations. So just to give an example, if I'm in England and I contract with an individual, and they, at that stage, are domiciled in England, they then get wind that there's going to be a dispute, it's a big claim, they might move to Spain.
Yeah.
They might move to Poland. And then I've got to go, and I'm now litigating in a forum which I had no idea that I was going to be involved in. Now, in this court, the change is far less significant, because in reality we're not dealing with moving between countries. We're talking really about moving from the CRIG, from the Dubai courts, to the DIFC courts. That is the fundamental effect of the judicial authority law, because everything else is controlled by foreign non-competence. If it's wrong, if there's some problem with hearing a foreign claim, then it can be controlled by foreign non-competence. So, in Europe, the claimant finds themselves having to cross continent.
Yes.
In Dubai, they're crossing the creek. It's not such a major change. So actually, the problem, if there is one, is less in this jurisdiction than it would be.
Well, on the facts of this case, it's crossing the creek. And I suppose one could imagine other facts.
Whereas perhaps...
Where the defendant isn't even in the UAE.
Correct. And then if there's a problem with that, my point is that foreign non-convenience comes to the rescue. So it all controls.
Yeah.
It all, well, it will if it's inappropriate for this court to hear the claims. There's some other clear, and I'll come on to the submissions on that.
Yes, I see.
So there's a common fallacy, I say, that sort of views the DIC as a separate country. It's a separate jurisdiction, but it is still part of the Dubai court system. It's the effect of the judicial authority law is the ruler is effectively saying these sorts of claims, so here is the pool of claims, these sorts of claims from that pool go to the DIC court, and it's up to him to decide that. And that's a developing situation, not just in this court, but in the whole UAE, but particularly in Dubai. Often, the jurisdiction where one finds oneself does change. And that is a feature of the Dubai legal system. Your Honour asked the question, are there any other jurisdictions which are based on claimant-sided status? And the most clear example of that is the Dubai World Tribunal, which deals with claims by or against subsidiaries of Dubai World.
Yeah.
So if you bought a flat from Nakheel in 2008, you would be expected to be litigating any dispute with a claimant or defendant in the Dubai courts.
Yeah.
And then late 2009, Decree 57 of 2009 comes out, and you are now litigating in the Dubai World Tribunal, which for all intents and purposes is the DIFC courts.
Yeah.
You're physically in the DIFC, you're sitting in front of judges from England. Yes, they're applying Dubai law, but they would do that anyway if that was the law of the contract.
Yeah.
So the reality is that this is not unusual for this jurisdiction. The parties' expectations, insofar as they have any of the jurisdiction, will differ from where they end up actually having the questions decided.
Yeah.
And there's nothing wrong, I say, in principle with that, particularly when, as I say, one just steps back from it and thinks, well, what really is the ruler doing here? Dividing up the sort of pool of claims which might otherwise come before the Dubai courts. So it's almost like, it's not like establishing a country, it's almost like establishing a division, specialist division of an existing court system.
Yeah.
It is different from that, I'm not suggesting that's all it is, but it's much more akin to that than the situation in Europe, where one moves from England to Poland.
Yeah.
And there is this decision in the CDM case. We don't have the judgment, it's in the Dubai World Tribunal, because of course the jurisdiction of the tribunal depends on the status of one of the parties being a subsidiary of Dubai World. The CDM case was a case in which it was a defendant, Nakheel, who was the subsidiary, and they had stopped being a subsidiary because they came out of the Dubai World Agreement. So then the question arose, well, what is the date at which to make that choice? And the answer was the date of the claim in that case. Yeah. And it was argued that the Dubai World Tribunal still had jurisdiction because at the time of the contract, Nakheel was a subsidiary, and that was rejected. We don't have the judgment in that case. It's not on the website of the Dubai World Tribunal, or I couldn't find it. What we have is the particulars of claim and the order.
Yeah.
So it's clear what was argued and it's clear what the result was, but we don't have the reasoning for it.
Yeah.
We know the solution. But the premise of my level for its argument is that the parties' expectations about jurisdiction should be met. I suggest that's wrong, particularly here where the move's not so dramatic. And indeed, in England, when the House of Lords looked at this question in relation to the Lugano test, they did consider the convenience to a claimant and the expectations of a claimant. And what they were dealing with there was this question of whether or not you decide the issue of domicile as at the date of issue of proceedings or as at the date of service of proceedings. And one of the points they made was, well, you might spend money investigating a claim thinking that it's in England, starting a claim in England, and then, as happened in the Stoltenberg case, after you've issued, the defendant gets wind of it and moves. And so they took the expense of actually getting involved in the litigation, gearing up to litigation in England, as one of the factors which led to them saying, well, it's more likely, therefore, to be issue than service, because you have those problems if it's serviced, but you don't have those problems if issued. But there was no suggestion in that case that a party who contracts with a defendant when that defendant is domiciled in England has some sort of legitimate expectation that they're going to be using the English courts. No, there's no suggestion of that sort of expectation having any bearing on the interpretation of that piece of legislation. And the bottom line is, I suggest, is that you're entitled to expect what the law provides. And if the counterparty, if you're in England and your counterparty moves to Germany, then you're going to have to sue them there. You're entitled to expect.
And at least on the fact that this case, the law was in existence at the time of the alleged transaction.
Yes. That's right, and so you know that if your counterparty establishes a branch in the DIFC, then there is a chance that you will be litigating with them here, subject to the non-convenience principles. At least you won't be litigating with them in the Dubai courts. There's also, it seems to me, a problem if we're dealing with expectation. And this, my friend places a lot of the emphasis on his argument for the expectation of the party, calls it arranging affairs, and so on. But the question then arises, well, the expectation when? At what stage do they need to have this expectation? As I say, and the data and material facts doesn't in my submission appear to work. If you're dealing with a contract, one might say, all right, if expectation is the crucial issue, then it's the expectation at the date of contracting. For contract, one can see that that makes logical sense. But then what about talks, which are non-consensual arrangements between, or non-consensual relationships between parties? And so this idea that expectation should govern the interpretation of statute just breaks down when we're dealing with talks. It seems to me it's impossible accurately to define by reference to expectation when a party should have such an expectation. The second sort of broad argument my own friend raises as well, he says, if you want, he calls it extreme forum shopping, if you want to establish this court's jurisdiction, all you've got to do, he says, is open a branch here. Because that, and he said, he makes this point in various ways, amongst that, he says that achieves the same result as a jurisdiction agreement. The first point, one might equally say, well, if you want to make sure that you can only be sued in the Polish courts, move to Poland. It's a pretty unrealistic argument, I would suggest, because implicit in his submission is that it is straightforward to become a regulated entity in the DIFC. So implicitly he's saying, well, at the drop of the hat, you can just open a branch and it's absolutely fine. We're dealing with a heavily regulated environment. Registration and regulation licensing is a process. It's obviously not open to anyone. One has to qualify for it. It takes time, costs money. You will have seen that in my client's case, the thought was had in 2008, but then put on ice for a while. But then started up again in 2014, and it appears to have taken several months to get there. So the idea that anybody, just to bring their claims here, sort of collect up disputes and then just register in the DIFC and have them registered here is not a realistic approach in my solution, because the gateway is the DFSA, the regulator. It's not enough just to open an office. We see that from the Seren case. Yeah. The license to do the business that one's engaging with. Yeah. Which has to satisfy the regulator and have individuals in place who meet all of the requirements. So that gateway, registration and licensing by the DIFC, is sufficient to filter out anything that is less than bona fide in that regard. So this extreme forum shopping example, it's not, in my submission, relevant, a consideration that can affect the construction of the legislation. And anyway, I make the point, it's not suggested, at least in this case, that there's anything, that the office is anything other than bona fide here. The second point is, again, once one accepts that the position as appears in the legislation is fine, when we're dealing with a defendant, it's hard to say there's a problem when there's a claimant. is if there is a problem, a defendant, on my learned friend's case, a defendant could obtain a license, become licensed and registered here, specifically so that it's protected from disputes in the Dubai courts, specifically to bring its disputes into the Dubai courts. My own friend's position is that's acceptable, it's perfectly acceptable. So again, what is the problem if that is acceptable, if that is a problem? Why is it not acceptable for a claimant if it's available to a claimant, when it's acceptable if it's available, that it is available to a defendant? And then the third point that he makes, it's one of the points he makes, is that this availability, this factor, abrogates the entire purpose of the opt-in provisions in the judicial authority law. And I mean, I don't follow that. It just doesn't. It's just another way in which to found the jurisdiction. And this jurisdiction clause in favour of this jurisdiction. There's no requirement that a party be licensed to establish jurisdiction. It's just for me to be an submission. There may be overlap, maybe circumstances in which both gateways apply, that they're two entirely separate tests, and the one has meaning on my interpretation. Article 582 has meaning on my interpretation. 501A on the literal meaning of 501A. And really, those 2 points are the sort of legitimate expectation point and the extreme forum shopping point. Those are presented, in effect, in various different ways. My own friend characterises in a number of different ways. He says, well, the literal words of the statute are contrary to the purpose of the legislation, absurd results, public policy problems, contrary to the scheme of the judicial authority law. But underlying all really are these two complaints. You can't predict where you're going to be sued, and you can create jurisdiction by registering. Neither of those solutions is absurd, and neither is contrary to the purpose of the legislation. And anyway, I can't rewrite the legislation. Now, on the issue of purpose, just to cover this, my learned friend says, well, the DIFC has no legitimate interest in having jurisdiction where the facts giving rise to jurisdiction arose after the facts giving rise to the dispute. That's his position. There's no legitimate interest in this court having jurisdiction. Short points. Firstly, the DIFC doesn't need a legitimate interest. As I've said, the ruler could decide tomorrow that all commercial claims in the Emirate should be heard at the DIFC courts. That's within the ruler's scope. Now, it hasn't gone that far. Judicial authority law doesn't go that far. But you could change the venue, just as you changed the venue for all claims by and against Nakhil, and has done so with AMLAC, and has done so with Zabil, all these other judicial committees that have been established. So one doesn't even get started on this. Does the DIFC, the question of does the DIFC have a legitimate interest in this? But it wouldn't be absurd, and it isn't absurd, to include claims of this sort, to have a provision in judicial authority law in these terms. It is, I suggest, perfectly reasonable to give this court jurisdiction over claims by licensed authorities whenever they were licensed. If an entity is licensed in the DIFC, it's been accredited by the DFSA to do business in the DIFC, so its business will be the sort of business which is transacted regularly in this jurisdiction. And so it is likely that the disputes arising from that business will be the sort of disputes with which this court is well suited to deal. Not just the subject matter, but the language and the law will be language and law and subject matter with which this court is well familiar, because these are the sorts of entities which will be established, will be licensed in this jurisdiction. There's nothing absurd about that at all. Secondly, Your Honour makes the point that this court is a facility which is available to those who are licensed and registered in the DIFC. Having confidence in this court is one thing that attracts parties to this jurisdiction. And so there's nothing odd about the fact that once one registers, one is in the DIFC courts. And in fact, my learned friend appears to accept this approach to discuss an argument, to some extent anyway. He says paragraph 26.1 of this case, I'm almost finished on this aspect, because this is almost my case. He says the purpose of claimant personal jurisdiction in the judicial authority law is to ensure that, one, the DIFC courts have oversight of those regulated carrying business within the DIFC, same as some sort of regulatory function, and two, to offer DIFC court services to those regulated carrying on business within the DIFC. Well, I fall squarely within his number two. The purpose of the legislation is to offer these court services to parties who register in the DIFC. Well, that's what's happening.
Yeah.
And that really, Your Honour, without wishing to labour the point, is all that I have to say about the question of jurisdiction, unless Your Honour has any.
No.
Next question is abuse of process. My learned friend repeats the points he makes on jurisdiction, and I've said so the complaints he makes about jurisdiction. So I've said what I say about those points, but then there's the additional point. This only arises if the court has jurisdiction.
Yes.
If the court has jurisdiction, the intention of the legislation is that this kind of claim should be heard in this court.
Yeah.
And so, if that is what the statute means, then my clients are doing exactly what the legislation is intended. So, without something more, which isn't legislated for, one can't even get off the ground.
Yeah.
I can see there might be an argument if, for example, my clients have started multiple claims in multiple jurisdictions. Then one might say, well, this claim is abusive because it's repeating something that's being done somewhere else. And that's the sort of standard circumstance in which abuse might become relevant at this stage. But there's nothing of that nature in this case.
Yeah. So
my submission just doesn't get started.
Yeah.
I don't know whether Your Honour needs to hear anything further from me on that. I mean, there are abuse arguments were run in some of the conduit enforcement cases. So you have in the bundle the NADAM and ban entry decision, for example, where it was said using the DIFC courts as a conduit to enforcement was abusive, and that's been roundly dismissed. There's another common decision which it was roundly dismissed as well. But it's never really been explained how any of that sort of activity could constitute abuse, other than to say, well, it's a bit surprising that this court should have jurisdiction, and lots of people wouldn't think that it should have jurisdiction, and the sorts of points that my own friend has been making. So that it just doesn't go anywhere in my submission. So I was going to move on and do it from more aspects.
Go ahead.
It's worth just seeing how the application framed this, because we moved on quite a bit. And Your Honour's heard what my own friend has said at the end about its jurisdiction agreement. My interpretation of his submissions is it was well over the line that I had understood Your Honour to have drawn. He says, well, this court should respect, in other words, enforce the jurisdiction agreement. I'll come on to that in a moment, but it is relevant just to see how the jurisdiction agreement was framed. Sorry, the foreign non-convenience argument was framed until we got my own friend's skeleton argument Wednesday. So if we just, I'll just show back to you, if I may.
Yeah.
Tab 3 of the bundle itself.
Sorry, what am I looking at now?
So it's the main bundle.
Main bundle.
Tab 3.
Yeah.
Page 2.
Yes.
And the middle paragraph. So, in the alternative, without prejudice to the foregoing, to the extent that the DIFC courts may have jurisdiction to hear the claim, they are not the correct or most appropriate forum to hear the claim and determine the dispute. Other courts may also have jurisdiction over the dispute and are better placed and a more appropriate forum for the dispute to be heard.
Yeah.
The DIFC court should decline to exercise jurisdiction. And when one looks at the evidence, one will see there's no reference to England being better or a better place to have it. The attack is simply on the connections with the DIFC.
Yeah.
That obviously is a problematic way in which to advance. In fact, it's a hopeless way.
Well, you can't. You can't just make a vague suggestion that there may be other
Correct.
places. You've got clear. You've got to identify a more appropriate time. The burden is on you to show that it is. But what's happened today is that it's now been submitted that England is no more appropriate forum.
Yes.
Now, at the end of the submissions in support of that proposition, there was references made to the jurisdiction.
Yes.
But without accepting that there was a binding contract containing that jurisdiction, because I don't think that the defendant would advance an argument on the basis of the jurisdiction. But the argument that England was the more appropriate forum wasn't exclusively based on correct. So you can address me on the other matters.
Yeah, I'll do that.
Yes.
So Your Honour has in mind the test, and it is elided, or it's glossed over by my learned friend, but the test is that there must be another available forum which is clearly and distinctly more appropriate than this forum.
Yeah.
So the burden is on my learned friend, it's a
Right.
heavy burden. It's not, as my learned friend would have it, simply a question of weighing the two and deciding that one might be better than the other. There's a clear and distinct test
Yeah.
in there which requires the defendant to show defendants to show that England is clearly better.
Yeah.
You can't, I say, do that. Probably don't need to take it to the authority.
No.
Having been through a number of times before, but Your Honour sets out the test of futility, and the factors which can be taken into account are legion, described as legion. But they do. It's said in Spigliard in particular, one is not just focused on convenience and expense, albeit that is part of the test.
Yeah.
So when the case law says it's not just convenience and expense, they're not saying it's not convenience and expense. That is part of the assessment.
Yeah.
But it does include those factors, including in particular the location of witnesses and the law. And the place where the parties reside and carry on business. Separately, from the convenience associated with their place of residence, their location is also important.
Yeah.
One authority I'd just show Your Honour very briefly, if I may, is the VTB case.
Yes.
Just a short passage from that at line 1040.
Yes, what's that, in volume 2 of the authorities?
Is, I think, in volume, the last one, volume 1.
Last one in volume 1. No, so the tab would be
14. Just a very short passage from,
yeah,
so page 399, please.
page 399.
This is from the speech of Lord Clark. So this is the point that in addressing this question, the court needs to have in mind the shape of the trial. What are the issues that are going to arise on the trial? So you see 399, paragraph 192, about halfway down. A number of points seem to be relevant on this part of the case. First, it appears to me that it's important for the courts to know what issues are likely to arise at the trial of the action on the merits. Only when the issues are identified will it be possible to compare the two jurisdictions. Principles now stated in Dicey, in which, having stated general principles, much as above, the editors say that in practice the defendant should identify the issues which are appropriate to be tried in the foreign court. It says it adheres to that view. And then it cites the case of the decision of Mr. Justice Eder at the bottom of the case, at the bottom of the page. In considering whether or not England is the most appropriate forum, it's necessary to have in mind the overall shape of any trial, and in particular what are or what are at least likely to be the issues between the parties, and which will ultimately be required to be determined at any trial. These were originally set out in 2 letters. I stress that I do not mean the defendant must set out his evidence in great detail, whether a foreign law or a fact. The purpose of the exercise is simply to state what the issues of fact are likely to be, so the court can gauge whether England is clearly or distinctly the appropriate forum for the trial of the issues. This is of some importance in this case because no evidence was put before the court on the merits of the claim by or on behalf of Mr. Malafive. Moreover, Mr. Hatfield submitted to the court in course of argument that Mr. Malafique was perfectly entitled to say, as he does, say to VTB, you're accusing me of being a swindler, you get on and prove it. Mr. Hackett added that the matter proceeded in both courts below, on clear understanding VTB will have to prove its case. As he put it, they will have to prove all 5 ingredients of claimed fraudulent misrepresentation, 6th ingredient in the case of conspiracy. It is from what Mr. Hackett said that at present he has no positive case. It's of course true that the defendant in the position Mr. Malafique is not bound to advance a positive case, but in the absence of a positive case, the focus of the court can only be on the ingredients of the claim. It should not speculate about the nature of any positive case that might be advanced in the future. So, the claim is that the contract arose that the defendants instructed my clients to settle, to sell these shares.
Yeah.
That my clients complied with that, and so my learned friend says it doesn't accept that happens. There will need to be evidence of that. There will need to be evidence about the creation of the contract, as your Honour has said. But after that, what needs to be established? Simply interpretation of the statute. Sorry, the contract. And then, presumably, it's not said that the defendants settled the trade, so their obligations will arise under the contract to repurchase the shares. That's the case, and that my client suffered a loss as a result of it. So there's 2 trades. There's one is the selling, and then the one is the repurchasing. There's a facts which will need to be established in it. My learned friend's perfectly entitled not to admit those at this stage, but he provides no positive case. And that is a problem for him, because his big point on fraudulent convenience is FZCO, Financial Services and Markets Act. But he does not explain in any way how that arises, what issue in the claim would be affected by that. And so the dicta that we have from VTB says that that's not therefore an appropriate issue for this court to consider, to take into the mix when deciding whether this court or English courts is more appropriate, because it hasn't been shown what aspect of the claim FZCO applies to.
So that's an outcome of the obligation on the party seeking to rely on having the burden of establishing in compliance with the Biliar approach that the alternative course is much better.
Correct.
Or distinctly more appropriate.
Correct. So one can't just come to court and say, well, this contract's governed by Russian law. One has to say, this is the element of the claim which will be affected by Russian law, and this is why it's difficult, or this is why it needs to be resolved. So my learned friend comes to this court and simply said, well, English law applies, and there's an act called FZCO. Maybe it will be relevant. But we don't know how it will be relevant, and that's just simply insufficient. He's not obliged to set out his case. But if he doesn't, he can't say that an issue will arise which doesn't come straightforwardly on the face of my claim.
Yeah.
And as Your Honour observed, the main crux of that, the real issue, will be whether a contract arose. And that will emerge from the correspondence between the parties and any conversations that they've had, and we don't have any evidence about.
Well, the Dubai regulatory rules are very, very similar to the UK.
Well, that's the second part.
As I know from bitter experience.
Well, I've not had as much experience with them as Your Honour, but what I can say is that it's clear that there are judges in this court who will be perfectly able to apply any aspect of it as means applied. So that's the second part.
You go to the relevant rule book, and you give effect to it depending on the submissions that have been made.
Yes, well, quite. Yes. And we hope that the advocates will direct Your Honour to the relevant bits. So there are 2 points about FZCO. One is it doesn't arise on the face of the issues that we can see have been raised today. So just
there's been a sort of shadowy indication that the defendants will seek refuge in the FZCO.
what aspect, what part, what bit of it? We don't know. And that's what Will Clark said. One can't just say, that there might be an issue about enforcement. One has to look, one has to decide from this perspective, from this point in time, what is the likely shape of the trial.
Yeah.
One can only do that by reference to the cases that the parties have advanced on their evidence. And the case that my client advances is a straightforward contractual claim. Yeah. And the response comes back in submissions, not in evidence in any other way. Completely unparticularised allegation that there might be some sort of regulatory issue. That's the effect of it.
Yeah.
The question is that sufficient to say this court is not the appropriate forum? It's not. But even, as I say, even if that were to be an issue, this court is well equipped to do it. Yeah. So what else is there? What else is there to connect this claim to England, to make it the more appropriate forum? My own friend pointed to a number of factors which he said were neutral. So he accepts that there's nothing particular about the evidence, documentary evidence, which would favour England. And the witnesses, I'd say that would favour the DIFC, because we have the 3 individual defendants who are living locally. So they're not in the DIFC, but we're talking about the convenience. My own friend says I'm not allowed to say anything about where people are outside the DIFC. It's completely irrelevant if people are in Dubai. As long as they're not in the DIFC, that's the end of it. I'm conflating, he says, the DIFC with Dubai. But if we're talking about the expense and convenience of the trial, it's obviously relevant that people live in Dubai, but in Abu Dhabi, just down the road. My clients have identified 2 witnesses who might be relevant to this action. One is Mr. Goodfellow. He has a flat here in the DIFC, and he visits here regularly, and he supervises the office where there are 5 members of staff. The other witness is not, it's fair to say, doesn't come to this jurisdiction as far as there's no evidence that he comes to the jurisdiction since he left the company. But there is evidence that the discussion has been had, he's willing to come. So he's the one person who isn't in this jurisdiction on a regular basis anyway. As opposed to that, there's simply no evidence of any other connection between the defendants and London. So what is really what it comes down to then? It becomes my own friend's point that, well, the place of performance occurred, he says, in London, and then he also makes the point that the shares which were purchased were listed on the London Stock Exchange. Might be right, might not be right. I don't know what the position is in relation. I have no evidence about that, so I assume that's right. I'm wrong about that. I don't take that point. Those are the same point, by the way, because the performance is talking about is the purchase and resale, sorry, the sale and the purchase of those shares. So that's it's the same point. But again, one has to think about the way in which the courts here would approach those issues at trial, and they do it in exactly the same way as the English courts do. There's just nothing specific about the English courts which makes them better placed to decide whether a trade occurred or whether it didn't occur. And one would expect that that would be a relatively short point that won't actually be the subject of any argument at trial.
Yeah.
The real issue, as one pointed out, would be whether a contract arose. So in favour of the DIFC, we've got the location of witnesses, I say, and the fact that basically all of the parties are in this region, in one way or another. Yes, it's a branch here and the main registration, but all of the parties are here. But stepping back, there are 2 particular factors, I would say, which bear on the inconvenience of this court, and they are service of documents and enforcement of the final law. Service of documents, there's obviously a treaty between the UAE and England for the United Kingdom for the service of claims. So my own friend says, we'll undertake to submit to the jurisdiction of the English courts. Will the defendants also undertake to accept service of English proceedings by email, for example, or are we going to be wrapped into a 6-month treaty-based service problem? Now, Your Honour may have picked up from some of the correspondence in the bundle, I wouldn't necessarily encourage you to read the correspondence. There have been real problems in identifying the location of the addresses of the defendants. So the claimants have asserted that the defence, some of them, who found the fourth defendant's address, but the second and third defendants live at particular addresses. The answer has come back, no, they don't live there. Not, no, they don't live there, they live over here. So the claimants are, the defendants are, I would suggest, being somewhat evasive about where they in fact reside. Now, it didn't matter in this case because there's an alternative service in any event. But those two problems on service will inevitably arise if we start proceedings in England. We'll have the problem under the convention between the countries, have to go through
But so there's already been effective service so far as this court is concerned,
yes,
pursuant to an order for alternative means of service.
Yes, that's correct.
Yes, well, I saw the order that was made.
Yes. There's also been a little bit of back and forth about the names of the individuals, just to give you on a feel for the sort of arena that we're in. And so the claimants, the defendants are saying, for example, that they're wrongly named on the claim form. We've used the names which appear in the email addresses.
Yeah.
And so there is doubt even about their names. So they're going to be faced with all of these sorts of problems. And the way it was put in the correspondence is that individuals with those names are not known to us. Individuals with that name are not known to us. You haven't properly served. And so on and so forth. So there is going to be considerable time taken to do all of this, and there will be considerable problems with service unless my friends will also undertake on behalf of these clients to accept service by email. All of that will take at least 6 months. I expect by which time this claim will be done. The second problem then is enforcement. Now, what happens at the end of the case? I've got an English judgment. I can't enforce it directly in Dubai. You suggested that would be possible. So in the Dubai courts. So we're trying to get to assets owned by defendants in other parts of the UAE. My learned friend's suggestion is that we bring that English judgment back to the DIC courts and then enforce it as a common law claim with a view to reciprocal enforcement into Dubai. And I make 2 points about this. Firstly, Your Honour will be well aware of the problems associated with the Judicial Committee that has been recently established. My learned friend raises it in a skeleton argument and reserves the right to make an application to the Judicial Committee in due course to resist that. So there are real doubts at the moment about where that will end up for conduit enforcement. There's some cases that have come out recently which have suggested that regardless of the clear views of the judges of this court, the view of the committee, the de facto majority, the split 3-3 usually in these judgments, it is that these are not appropriate cases for the DIC courts to hear. And that is just a huge amount of uncertainty about whether or not in 6 months, 10 months, 12 months, when we get a judgment in the English courts, we will be able to. So is my learned friend willing to undertake, or his clients willing to undertake, but they will not resist the enforcement?
I think the answer to that question is pretty obvious.
Not quite. So one then starts to see what the purpose of all this really is. But the next point on that is what my learned friend is proposing is actually going to end up in proceedings, a claim by my client in this court in any event, just 10 months down the line, and we'll be arguing about the judgment. It'll be a common law claim in the judgment. So his solution, the thing that makes the London court more appropriate, clearly more appropriate, one of the things, is that it's possible to have 2 claims instead of 1. Because that will be the requirement. We'll have to go to London, fight the dispute, if the defendants want to participate, they may or may not. It doesn't always happen that way. We'll have that claim in the English courts, and we'll bring it back here, and then we'll justify it. We'll have an argument about it all in this court, and then we'll push it through the Judicial Committee, of course, which will take another 6 months, and that's the process. If we're going to end up in the Judicial Committee, we might as well get on with it, not do it in a year's time. I say that it's redolent of really the approach of the defendants here is a blocking strategy.
If the action proceeds here, And if there's a judgment in favour of the claimant,
Yes.
then that judgment would stand to be enforced through the onshore courts.
Yes. Yes.
And is there any foreseeable risk on that scenario of things ending up with the JJC?
Well, my old friend reserves his right to apply.
Yes,
to
but
the
what do
JJC.
you say?
So he will presumably say that the defendants are, yes, some of them might have to assert, are resident in Dubai. Therefore, the Dubai courts should have jurisdiction.
Or over the claim that's given rise to the judgment?
Well, yes, that will have to be his client's position. Whether he takes the point early, or whether
There has to be a conflict of jurisdiction.
yes, so he will have to start a claim. But I've seen that happen, and he's reserved his right to do it. So that must be the intention.
So whichever court this is tried in, whether it's tried here or in England, could lead to applications to the JJC.
It could do. It could do. That's right. But yes, that's right. But I don't say that JJC. I mean, I would say the JJC is more likely when you're dealing with conduit enforcement.
Yes.
Because the cases in which the JJC has come down against the DIFC are often, not exclusively, but in almost every case, bar 2 or 3, have been about conduit enforcement.
Yeah.
And in some cases, the way those cases have been resisted is to start some sort of process in Dubai, be it some sort of claim under the same contract, which is one of the most recent cases. Yes. So I would suggest that it's more likely to be raised in a conduit
On a conduit case and done otherwise.
but I suppose it might be raised
Yeah.
against me.
Well, if it's equally raisable, it's a neutral factor.
Of course, save that it gives an indication. I don't say it's equally raisable. I say that I say there's more prospect that it's going to happen with the judicial.
Yes. If it's a conduit
judgment
case.
case.
Yeah.
What I'm dealing with here is my learned friend's point that enforceability isn't an issue because I can go to the English courts. But
Yes, well, that's right.
yeah. But what I'm saying is that
He referred to the protocol.
yes, but what I'm saying is that it seems to me that then doesn't just look at the possibility that the JJC might be invoked. It looks at the likely prospective outcome of JJC proceedings in relation to that. And the outcome, as I've said, has been negative towards foreign judgments, regardless of what an English common law judge would think of the merits of the arguments raised in those cases.
Yeah.
Whereas if we have what I would suggest a very straightforward situation in this court, where one has a DIFC establishment making a claim,
Yeah.
then it's a much more straightforward argument, and one doesn't have to navigate around the decisions that have already come out of the JJC.
Well, that's about it, isn't it?
That's
as far as
about
your
it.
submissions are concerned. Is there anything else?
Unless Your Honour wants me to deal with the jurisdiction agreement, then I can leave that. It seems to me that the jurisdiction agreement only affects the case if my learned friend relies on it and says that this court should enforce it. Because otherwise it's just a clause in the contract.
Yes.
It doesn't really help.
Well, it's a clause in a document which is not accepted by the defendants as constituting a contract.
Yes, exactly. It doesn't help you on answer the fundamental question, which is what is the shape of the trial going to be? Is that trial better here or there? It doesn't actually impact on that.
Yeah. All right, well, thank you very much. Mr. Chair?
Yes, my Lord, if I bullet points in reply, if I may, I'll be as quick as I can.
Sorry? How long do you think you're going to be? I don't feel under any pressure, under any expectation that you're going to gallop, at a very, very fast pace.
I mean, I wouldn't hope to be more than, say, 50 minutes max. I think I'd be very long.
All right.
But if my Lord you'd rather rise...
No, 15 minutes is fine. But if it starts veering towards half an hour, I think we'd rather have some lunch before we hear you.
Well, the other thing, of course, is I could do it slightly quicker if we had a break for me to gather. I mean, if we
Well,
have
it's 15 minutes of realistic estimate.
there's a risk I could go longer.
All right. Well, we'll resume at 2:05.
Right.
All rise.
Good. 2:05.
Well, there were, so I talked to that folks because they don't have any experience Do you guys want to make a start to the field? Just grab a table? Yeah. No, that's very English. He was basically came out and spoke to the
really? What? Just to replace them? Previously, there's one particular. I was. Oh yeah. Yeah. If you think about progression,
Sorry?
did you put the heating on?
That's something did. You guys okay, or did you not?
Yeah, just freezing away.
Yeah. It's okay now?
It's comfortable.
Yeah? Okay.
So it's flat orders, this is the edge, and this is the thing. Cooling comes in at the edges, so everyone inside is freezing cold.
At least you don't have a problem with it as weeks versus normal.
Oh, I know. But in Ramsden, there's no problem. That's not much fun. Speaking for 3 hours. Long straw.
All right.
Well, if I could start with the learned friend's submission that this question isn't in fact open to this court on the authorities that you referred to. I say that's wrong. First, Corinth left it open. That's paragraph 71. Secondly, in AFRAS, I relied on the additional claim as a point of context rather than saying there's some kind of necessary and proper gateway requirement. Rather, the point was neither argued nor did the defendant fully argue the point. So, the Lord, you're not.
But Justice Chadwick said what he did.
Yes, he did.
Yeah.
But he said what he said.
It wasn't it didn't have this temporal element.
That was my third point. You're ahead of me. So yes, of course he said what he said, and I can't go and say that. But it didn't have this specific fact pattern.
Yeah.
And the full range of argument wasn't counted.
I'm not bound by any first instance decision, but the convention is that a judgment given by a judge of first instance ought to be followed by another judge at the same level, unless there are good, stateable reasons for not doing so.
Yes.
But your point is, well, there isn't even a first instance decision that actually covers the point in this case.
Exactly.
Yeah.
I don't know, I suppose as an alternative I'd say if it did, then the temporal factor is a good reason to depart from.
Yeah.
And secondly, the Seren case also expressly left it open at the end of paragraph 17, saying if the registration were completed, that would give rise
That was a slightly Delphic sentence. That's exactly what the judge had in mind when he said that. But anyway, there it is. Again, he said what he said.
Yes. So that's my first point on the authorities, which is it is still open.
Yes.
And my second point is that against me it is said this is an impermissible exercise of interpretation because I look too far to the purpose of the statute. The entire battleground is a question of how far one can go, so I'm not going to repeat everything I've said before, but I would just draw your attention to paragraph 58 of Carafi, which is, in construing Article 5A, it's necessary to keep clearly in mind the ultimate and dominant text is in Arabic. This court is using a translation to arrive at the true meaning and intent. It's to remember that Arabic may not lend itself to as precise a facility of expression in legal phraseology as English. That's why it is important, this is the sentence I rely upon really, when construing DIC legislation such as Law 16, not by a literalist construction of the English text, to lose sight of the legislative purpose underlying the text. So I say I allow the purpose, and I may get there or I may not. What my learned friend says is just...
But what you haven't done is to adduce any expert evidence on the Arabic language to say that is, in the English version, is not a proper translation from the Arabic version.
No, I don't rely on that. I use that statement to say one ought to look at the purpose.
Yeah.
And I accept some of the difficulties that have been raised against me.
Yeah.
In terms of on a literal word.
Yeah.
My learned friend relied on the Prince of Hanover case, not wishing to descend into the history of the Jacobites, but it's obviously a very different context. And the main point I would take from that is actually I don't dissent from the section at page 467 that the learned friend relied upon, where he said you need to look at the legal and factual context. Again, it's just part of the interpretive exercise. And the risk.
It is all abundantly clear without looking at the preamble. The preamble can't change that, but if it isn't abundantly clear, the preamble may assist in...
Yeah. It's the ordinary contextual interpretive exercise. Yeah. So that's authorities. Practicality. My learned friend suggests that selecting some kind of time may be difficult. That overlooks the fact that this court already does that under gateways B and C of 5A1. So when one has a transactional link, there are civil or commercial claims or actions arising in it or relating to a contract or promised contract, whether partly or wholly concluded, finalised, or performed within DIFC, or will be performed or is supposed to be performed within DIFC pursuant to express or implied terms. Now, if that court can make something as on its base general as that work, with all the potential difficulties on the margins about a contract, there's no reason it can't do the same in this case when dealing with temporal matter. My Lord raised the issue of perhaps rephrasing my test in terms of cause of action accruing. I accept that would be a reformulation that would be more precise than my use of material facts. But again, that's the sort of exercise that a court does all the time. So to suggest that it's not something that this court can do,
yes, that's it.
Isn't right.
Yeah.
My last series of points turn on the defendant is different point, if I can put it that way.
Yes.
Now, there's an analytical difference, first of all, which is the claimant brings the case, so forward shopping risks arise. And secondly, defendant-sided regimes are known and set out fairly regularly. So yes, whilst I accept on my case on the wordings I'm treating claimant and defendant differently, I say there are good policy reasons underlying that, and and it's clear. On the related point of a move from the DIFC to the buyer saying it's not a major change, we just come down the road. Whilst that's superficially attractive, it's important to bear in mind it's not just a change of location. There's a move from a civil law system to a common law system, from proceedings in Arabic with all that, with all the procedural rules over there, to English and the rules of this court. So, whilst of course the distance may not be great, my learned friend downplays rather the systemic differences that do exist. My learned friend relies on the DWT. Well, that was a specific response to a specific set of circumstances, and it would, in my submission, be wrong to translate that specific legislative policy response over to a general law such as the JL, which is designed to set out the general jurisdiction of this court.
Yeah.
A temporal point was taken that there's no issue of retrospectivity in that the DIFC existed at the time of the contract. Now, there's an underlying assumption on that basis that a contracting party ought to know all the laws in the world and all the risks of jurisdiction that it faces when dealing with a counterparty. That's my point earlier, that actually that is too high a standard, and one shouldn't expect perfection from businessmen. That's just not realistic.
Well, you say you're not a contracting party. If you were a contracting party, it would have been open to you to specify jurisdiction.
Yes.
Would you say you weren't a contracting party?
Correct.
Yeah.
But for the purposes of jurisdiction, we're stuck with the case that's being put against us because we're not going to be able to determine that at this jurisdictional phase. And I'll come back to this when I'm dealing with the jurisdiction clause, but it's the conceptual tool is that it's the law of the putative contract and the jurisdiction of the putative contract that will lead to the dispute being determined. So I can't, if I said there's no contract and therefore I shouldn't be a party to this, that wouldn't help me. That's a consequence, I suppose, of not being able of having to determine jurisdiction at a logically prior stage to determine a substantive dispute.
But you're making a general point about uncertainty that will get in the way of commercial enterprises managing their affairs and their risks.
Yes.
But at the heart of that general proposition is the idea that there are contracts which are made,
Yes.
and thereby the opportunity arises to specify jurisdiction.
Yes.
Now, I take your point about in the instant case the contract is put into dispute, but your point goes more generally.
Yes.
And what I'm putting to you is that in respect of that general point, the parties have the autonomy to specify in respect of any contract they are entering into what the jurisdiction or governing law will be.
Yes, they do as a matter of principle.
Yeah.
But that's where I say there's a difference between holding parties to a standard of perfection and something lower. If one is a purely internal party dealing with another wholly internal party, it's very easy for lawyers to sit here and say, well, you ought to include a jurisdiction clause, just in case. But one can ask rhetorically, ought that party to be expected in the course of its ordinary dealing with another internal wholly domestic counterparty to include a jurisdiction clause in its contract?
Well, if there are internal parties, it's very, very easy to see whether one of them is a licensed, registered entity, or whatever the phrase is.
Which is precisely my temporal point. It's easy at the time to see if they're registered. If 2 years, 3 years later,
Yes, no, I see your point.
they don't.
Yeah, I see your point. Yeah.
my learned friend says, I presume the assumption it's easy to open a branch here. Of course, I accept it takes some time and it costs money. But my learned friend argument can't have it both ways. He can't say a benefit that's being offered on the DIFC court services, while at the same time saying those services are irrelevant to the benefits of incorporation. So I do say that if the DIFC courts are attractive, and that there is a risk of forum shopping that arises from that, unless there is the sort of temporal restriction that I'm talking about. Finally, I was picked up on suggesting there was some kind of legitimate interest.
Yes.
By that, I mean that one needs and ought to construe the existing laws against the existing legal structures, which includes the purposes and the objectives of the DIFC, which I referred to in my submissions, and the other elements of the law, including, for example, the general defendant-sided jurisdiction and the risks of forum shopping that arise. So that was just an attempt by me to tease out exactly what the purpose is behind the law. But I'm not suggesting I, here as the advocate, is the one who selects or indicates what those interests are. I take them from the existing legal structures and other parts of the same contextual exercise. That's jurisdiction. I've got 1 point on abuse.
Yes.
Which is, my learned friend says he's just using the law, essentially, so my abuse argument,
Yes.
paraphrase.
Yes, that's essentially what
That's essentially the point.
Yeah.
If that's right, then there could never be an abusive process. And that's why in my skeleton I refer to that part in Johnson and Gort Wood, where it's doing something that is technically within the rules, but that offends the court's sense of managing its own jurisdiction. So that can't be an answer, otherwise one would never have an abusive process.
Well, to the extent that you seek to say that there is a concept separate from FNC, which the court, in the exercise of its inherent jurisdiction, can take account of. At the moment, I find it a little difficult to contemplate a situation where, if the claimant's construction is the correct one, where there would be room for the concept of abuse as distinct from FNC. Can you give me an example that I could would help illuminate what the room for operation of the concept of abuse would be?
Well, I'll give two examples.
Yes.
One example would be this case, where on the current evidence there is nothing to suggest there was deliberate incorporation of the IFC in order to invoke the jurisdiction of courts. And I say in those circumstances the abuse arises because of the claim itself and invoking of the law. It's essentially vexatious for my clients to be dragged into these courts in those circumstances. The second example would be if there were evidence that a party had somehow incorporated itself solely for the purpose of bringing a claim.
Yes, a kind of sham argument it would be that there was no genuine intention to operate a branch office. They've simply gone through the motions of incorporating, because let's say, for the sake of argument, there's a very enormous claim which makes it worth the expenditure of a bit of window dressing.
Or even, not even, it wouldn't even, that would be the most abusive, as it were, one very enormous claim. But one could imagine a series of smaller claims or potential smaller claims in the future, and one just has a DIFC branch registered sitting there as a conduit, but a sort of a pre-judgment conduit rather than the post-judgment conduit.
Yes.
So they're the examples on that.
All right. Thank you.
forum non-conveniens, insofar as it's said against me that I don't have enough evidence, my response to that is quite a lot of this is properly a matter for legal argument. Of course, the facts on which I rely ought to be in evidence, but insofar as I say, well, hang on, the factors on the face of the evidence point to England, that's something I'm entitled to do. I accept your recent formulation of the Spiliani test insofar as there's any suggestion of a difference between us in terms of what I need to show.
Yeah.
It was suggested that I haven't set out in enough detail, particularly on FZCO, the FZCO challenge.
Yes.
Now, there are two important points of distinction here. The first is that we don't know yet what the full claim is. There's only the brief details of the claim. There aren't the full particulars in the same way that one would ordinarily see particulars of claim. And two consequences result from that. First of all, it's a matter of fairness to both sides. If they're allowed to rely on the brief details, then so ought we to do. And secondly, you have to be very careful when you take the learned friends' English authorities, which are likely to be in the context of a fully pleaded claim.
Well, aren't they? Isn't jurisdiction taken before any defence is served? You enter an appearance subject to jurisdiction.
Yes,
you don't do anything else.
No, I'm not saying there's a full pleaded of a defence, but there would often be full particulars.
Full particulars of the claim. Well,
not the commercial court.
I don't know. At the moment, the claimful pleads the trades, the parties, and what the settlement payment obligations were. I can't see that you need any more than that for you to formulate a FZCO defence. I mean, it could be on the basis that if there were this contract, which you deny, then the following FZCO defences, if you like, would arise or are sufficiently potential to arise to be taken into account on an FNC investigation. But you haven't done that.
No, I accept that, and that's when my response comes back to my first point, which is they have only set out in very brief form what they say, and so it'd be unfair to require.
But your people know the extent of the dealings they had with the claimants.
Yes.
They also, or their advisors, know or can acquire the knowledge of the FZCO requirements, drilling down into the different rule books and code of business and so on. And on the basis of what the individuals constituting your clients say as to their such dealings as there were, you would be in a position to foreshadow FZCO defences, which I think you'd be entitled to say it's not absolutely certain you're going to take them, but there's a sufficient probability for the court to take them into account. But all we have here is a shadowy suggestion that FZCO is going to feature in one way or another.
Yes. I mean, requiring more than that would put parties at this early stage to...
Well, I can't see how. All you've got to do is for your instructing solicitors to take the sort of instructions, after all, they've already taken as to what happened as between them and the individuals constituting the claimant as far as this claim is concerned, and for someone to turn up the the London regulatory provisions.
Yes,
Bearing in mind the burden's on you. I mean, that couldn't be clearer from Lord Goth's speech in Spiliata.
yes,
Anyway,
I accept that. You have my.
yes, I've got your submission.
Insofar as I was suggesting that certain factors were neutral,
Yeah.
as between the DIFC and here, the issues remain that in my submission nothing points towards the DIFC. The learned friend relies on two factors, service and enforcement. I ought, perhaps, at the risk of descending into some of the back and forth between the solicitors on this, Clyde & Co. in two letters did say that they would accept service. And in the course of that second letter, they said, you've not named the person quite correctly, we think you mean this person. So, I mean, it's not really a matter for today. I don't want to get bogged down.
No,
into it,
well,
but
I can assure you that I'm not particularly interested in that aspect of the story.
In that case, I shall move on. In terms of the advantage of service, my learned friend, one of the points my learned friend made was that they've already served here.
Yeah.
Well, that's always going to be an answer in any jurisdiction challenge anyway.
Well, it's always going to be a factor,
Yes.
inevitably, because otherwise you wouldn't be before the court. I accept that.
Sorry.
And, however, if service in the alternative jurisdiction, which is being contended for, would be lengthy and problematic,
Yes.
the court could take that into account, can't it?
Well,
Amongst everything else.
it does, but it needs to be careful analytically not to put the cart before the horse. If I can perhaps move on to a different metaphor, it's a bootstrap argument, in that any party who goes off on issues wrongly, let's say apart from service, there's no other sensible basis for the jurisdiction
Yeah.
on FNC.
Yeah.
There's any jurisdiction challenge where the respondent sets out his position, says, hang on, the centre of gravity is all over in this other jurisdiction.
Yeah.
Placing too much weight on service allows the claiming party essentially to benefit from its own wrong and steal a martial jurisdiction because it's got service. So, whilst it's listed as a factor, it's a factor that's open to abuse, and actually, in my submission, ought not to be given.
Well, what about this point? Is it not implicit in an undertaking to submit to the jurisdiction that you undertake to accept service? Because you've got to be served to be within the jurisdiction you're submitting to.
Yes.
And I would have thought that the party offering such an undertaking through its solicitors, is accepting that there can be service on the solicitors, whose name would have to be on the forms following the submission to jurisdiction.
Well, that accepting that there would have to be service in accordance with the relevant rules.
Well, as far as I remember, if solicitors say they will accept service, well, then you just serve on the solicitors. In which case, there's Mr. Montague Smith's point falls away, it seems to me, because service won't be frightfully problematic. It's an entirely neutral point, and you won't be troubled in having to respond to it.
Yes.
As you know, the whole trend in commercial courts these days, certainly in London and in this court, and I'm sure in Singapore, is to adopt sensible, practical approaches to problems like this. And I think, well, it's never, at this point, it's not arisen in my experience in the commercial court in London. But if it were to, I would be much attracted to the point that I've just made to you. That it's an empty undertaking to submit to the jurisdiction. If you require service to be made in a way which could take many months, as it can do, having to go through diplomatic channels and the like, and which is somewhat fraught with the risk of technical deficiencies. Well, can we leave it like this? I heard what Mr. Montague Smith had to say about service, but he had other points as well, and I don't think he's going to be a crucial point, what he had to say about service. He amongst his other points are the burdens on you.
Yeah.
You have to show that England is distinctly the more appropriate jurisdiction. And really, when you look at the facts in a commonsensical sort of way, these matters are either neutral or one's cancelled out by another, and therefore, he says, you don't get over the hurdle that you have to get over. And I think that's the broad approach I'm going to take to this question. So I'm not going to make any binding declaration as to what is implied in an undertaking to submit to the jurisdiction. But I do raise that point for consideration. I think it's worth
Yes.
some thought. Right.
Noted.
Right. Any other submissions?
Well, in terms of the factors for and against, they have their weight.
Yeah.
The best point Winifred has is he's got it started served here.
Yeah.
And I caution against allowing him to pull himself up by his bootstraps.
Yes.
Or have a circumstance where the centre of the gravity of the contract in itself is over in England. And that's why I say when you look at the legitimate factors and apply that proper weight, England is clearly and more distinctly appropriate for it. In terms of enforcement, which was another matter Mr. Montague Smith raised, all his submissions in my submission were speculative as to what would happen in the future, whether or not in the DIFC or in England in terms of enforcement through Dubai. It's highly likely that by the time any trial was to have been decided, the position will be a lot clearer. These matters will have been determined. And so in those circumstances, I say this...
Things don't necessarily move in certain quarters here at the speed of light.
No. But it's pure speculation on the part of Mr. Montague.
But I think he may have a point that the conduit jurisdiction applicable if judgments obtained in London and sought to be enforced onshore in Dubai is likely to be more vulnerable to JJC intervention than if the judgment is a judgment of this court and then sought to be enforced in the ordinary way through the courts of onshore Dubai.
well, two matters arise.
Yeah.
First is that can't be put in any higher than likely, so
Yes.
there's necessarily a degree of
That's a fair point.
Secondly, in circumstances where there is exorbitant jurisdiction here, in circumstances where the defendants are based in offshore Dubai, and one would expect in the normal course of events Dubai to be the forum where these disputes were heard, it is equally likely, if we're going down the speculative route, in my submission, it's equally likely that the Dubai courts are going to have similar concerns about the scope of the DIFC's jurisdiction in this case. In that, if it's improper for jurisdiction to be moved away from offshore Dubai to the DIFC via a conduit jurisdiction, it's also improper for that to be moved away by an interpretation of the law that runs against the ordinary rules of jurisdiction. Now, there's necessarily a substantial amount of speculation built into that submission.
Yeah.
But insofar as there's a controversy,
Yeah.
it is at the lowest, a very similar controversy in terms of scope of jurisdiction.
Okay.
If I may finish on the jurisdiction clause.
Yes.
The claimants have signed a statement of truth saying this is what they believe the contract is, and they are now bringing this claim in breach of that contract.
Yeah.
It doesn't lie in their mouth to try to get around it. They're saying we want this contract to hold. If they are seeking the assistance of this court in so doing, they ought to be held to their bargain, which is to litigate in England.
But that clause isn't an automatic red card where they have to go back and sit on the bench. It requires you to challenge the jurisdiction on the basis of the clause.
Well, it requires me to challenge it on the basis of it being a putative clause. It's the law and jurisdiction of the putative clause. I don't need to positively assert that there is a contract at this stage. I have to accept at this stage their case.
Well, I'm not sure about that. I can't think of a case where the existence of a exclusive jurisdiction clause has been relied on in a dispute as to jurisdiction, where the party making the assertion does not assert that this is a binding clause.
Well, one can posit, for example, say a misrepresentation claim,
Yeah.
where my client is sued in misrepresentation. My client will rescind the contract, so, for example, and then they get sued on the jurisdiction clause in that contract.
I'm being a bit slow, sorry, you'll have to put that again.
This is a case where we're arguing no contract.
No contract.
But posit a case where there's an invalid or an arguably invalid contract.
Yeah.
That contract has been rescinded. There's a dispute about whether or not the contract has been validly rescinded, or whether or not there were in fact valid misrepresentations made that were actionable.
Yes.
Claimant then sues somewhere else. I say it'd be open to the defendant to say, well, hang on, you're bringing this claim. You're the one that's saying this contract is valid. And you can't have your cake and eat it. If you're saying this contract is valid, then you ought to abide by your bargain. I mean, in the I think it's the Fiona Trust line of cases.
Yeah, that's right.
Law of
In the arbitration cases
Yeah.
where the arbitration clause is regarded as a separate contract, and the question is whether the parties contracted in those terms, regardless of the dispute about the validity or enforceability of the rest of the contract. But if that's the right approach, isn't that against you here?
No, because if the principle is that the law or jurisdiction of the putative contract that ought to determine the issue, and I always wrote to ought to determine its own jurisdiction on competence type basis, then at this stage the proper approach is to give effect to the validity of the alleged clause. In exactly the same way that if it were alleged that the contract had Russian law or whatever, any initial argument on the jurisdiction would be determined by reference to Russian law as the putative law.
Yes.
No. Yes.
Mr. Montague Smith said at a very early point in the proceedings
Yes.
that if he'd known this point was going to be taken,
Yes.
there would have been further steps undertaken. I think he mentioned this to evidence, and I think it would also be probably in respect of legal submission. Because if you're right, and that you're entitled to hold the claimant to the contract putatively,
Yeah.
then that opens up the question whether or not this is the sort of case where the court can assume jurisdiction contrary to the exclusive jurisdiction clause, and there's a body of learning on that we all know about.
Yes.
But Mr. Montague Smith hasn't had an opportunity to deal with it.
No. But I mean,
And I'm sorry to cut you
No.
short. And I just don't know, maybe neither of you two know, of any case where this has come up. There may be a case out there, but no one's turned their mind to it, because this is a Johnny-come-lately point.
yes.
And it may be, I'm just thinking aloud now, that I ought to allow the parties to serve some written submissions over a short period of time, dealing first with the question, can you pray in aid, and can you, the defendant, pray in aid the choice of law and jurisdiction clause in these circumstances? And if you can, what you say about that in terms of forum non-convenience, I suppose it is, and for Mr. Montague Smith to address the same points. At the moment, Mr. Montague, I think that's probably the fairest way of dealing with this. I'm slightly uneasy in following through my initial response to this, which was following your approach, which was to say, well, this point's not open to the defendants because they're not accepting that the contracts that any contract was concluded.
Can I deal with what my friend says about that now?
Well, I'd rather hear your response to my practical suggestion as to the way forward, because if that's implemented, you'd have every chance to say what you want to say now to me,
Yes.
but it would be in a context where the court's approaching this aspect of the case without having effectively determined that it's not a point that's open to the defendant. And I'm uneasy on reflection about reaching that conclusion on the state of play as it currently exists.
I can understand that, right? I think 2 points, I think. The first is that my own friend has had the opportunity to make his submissions on this, so it's not clear why we should end up with an exchange of submissions to give him another opportunity to make a case which he says he's made.
Yes, but I think I want to be assisted by some legal research. I'm entitled to look to counsel for help here.
Yes. Well, what we've heard what my own friend says about it, he
Yeah.
says it all flows from fear and trust, and I can answer that in writing, I can do with it now. But it's not obvious to me why it should be for him to say, well, here's a whole other series of bases on which I say that this argument works. It's going to fuel the proliferation of points. So that's a sort of practical point. But I mean, just to get back to the question whether we can just deal with it, whether this point to be open to my own friend, because ultimately we've had no explanation whatsoever of why we have this new point, which is a totally new point on the day of the hearing. Comes on the day of the hearing. The request comes yesterday, apropos of what? And the concern from my side is that this is just an ambush. This is a deliberate ambush. And so the question is whether the court should entertain it in this circumstance.
We can deal with that rather tendentious point in costs, if necessary. This is something which, as I said, it's a Johnny-come-lately point.
Yes.
And let's assume for the moment, without having heard submission on the factors, it was a point that ought to have been taken earlier.
Yes.
And we're having to spend time and money on dealing with the point in the manner that I suggested. I mean, that could end up with a cost consequence so far as the defendant is concerned.
I think just to follow it through, and I won't labour this because Your Honour clearly has a view. Just to think down to where this leads. The saying my learned friend is right, and he can rely on this clause. Even though he says there's no contract, he can rely on this clause. What does that do? It would then, in theory at least, shift the burden onto my client to establish solid grounds, real grounds, strong grounds, as to why the court should never let hear the claim.
Yeah.
So I've shown one of the way that this application has progressed, from saying there might be other courts which could hear this claim, to my learned friend's skeleton argument which says, well, actually it's England, to this morning, well, actually, not just England, but we've got this jurisdiction clause which we're entitled to rely on. So the shape of the whole case changes, and one's dealing with a case here which is worth $858,000. It is a modest claim. And so my client's approach has been to try to deal with this in a way.
But if we'd been in England and that you made the normal ex parte application on the papers, you would have been bound to draw this.
Correct.
To the,
yes.
And I'm a little uneasy that the court's kept in the dark about this clause. You see, in your claim form, which is the originating process, you pleaded the agreement. And I'm a little uneasy that this clause isn't adverted to.
Well, Your Honour, I would suggest a harsh criticism or a potential concern, because the problem for lawyers in these sorts of circumstances is that either they have an obligation to disclose something or they have an obligation not to disclose something, acting in the best interest of their clients. Now, in all fairness, my clients consider that clause is not a reason to send this off to England for various reasons which we will get into if we have to going forward. My clients will be prepared to put that case forward if necessary, but they can't be. My lawyers, my sisters, can't be criticised for not
Well, maybe
raising
not.
points against their own clients, as you say.
I keep saying this, in the modern era, it's cards on the table, and let's really get down to the true merits. Anyway, I'm going to.
I've heard what your point is.
Thank you for your submission. I'm going to direct that the defendant can have 5 days in which to serve short and concise submissions on the issue as to whether they can rely on the jurisdiction clause for the purposes of contesting jurisdiction in circumstances where they deny that the alleged contract was concluded. And secondly, assuming that they can so rely, how do they put their case as to the impact of this clause on the question of FMC? And the claimant can have 5 working days to respond, and then 5 working days for any threads that are still hanging out but need tying off. So we're talking around 15 or so working days. You have to chuck a couple of weekends in there. And to be frank with you, I've heard 3 separate cases since Sunday, and you weren't going to be getting a judgment earlier than 15 or so days from this hearing. So we won't be slowing down the wheels of justice. And I will take into account these written submissions in coming to my overall conclusion in the case.
Your Honour's given my clients permission to put in written submissions.
Yeah.
My point is that if the evidential burden shifts to me, it may be necessary to put in evidence. Now, obviously, that's something.
No, that's all right. If they can go into bene esse. I give leave to both sides if they want to put forward relevant evidence. We don't want this to grow up into some great big piece of collateral contest. Yes, you can put in evidence di bene esse. All right. Do you have any other submissions, Mr. Chair?
No further submissions. Tiny points of clarification. Do I understand that we have 5 working days as well? I think you said
That's
5
right.
days, then
Well,
working days later.
yeah.
I was just confirming. Thank you.
Yeah, 5 working days, weekends off. Right. Well, I'm grateful to both sides for their submissions, and I shall reserve my judgment, as I've already indicated. Thank you very much.
All rise.